You stated, I believe, that the minor contributor was less than 20%, and that it was actually 5%. The ratio is 5% to 95%.
For one of the samples, yes.
Do you remember that?
Yes.
Does that mean the 5% was from twigs, and the 95%, that 95% is assumed from the defendant, the Robinson?
When I calculated the statistic, Twiggs's DNA profile aligned with the 5% contributor, and Mr. Robinson's DNA profile aligned better with the 95% contributor.
Okay. Same question with regard to 8. I think you said the ratio is 11% from the minor and 89% from the major. Is that Twiggs being the 11% and Robinson being the 89%?
Yes, Twiggs better aligned with that 11% contributor, and Mr. Robinson better aligned with that 79% contributor.
All right, people, let me bring up my face here. We're going to get into this today because the hearing, I took myself out, put myself back, add, remove. I'll figure this out. It's my first time doing it. Good afternoon, ladies and gentlemen. How goes the battle? Viva Frei, former Montreal litigator turned current Florida Rumbler, not yet back in the sunny and free state of Florida, following the Tyler Robinson preliminary hearings, or the preliminary hearing, and fighting with people on the internet, because that's what this is all about. And I say fighting when it's actually about just trying to make sure we all actually understand. It seems the long forgotten objective is first understanding and then coming to your own opinions. You just got to make sure you understand the course material before you can actually take it and adapt it into your own opinions and theories, and make sure that the course material is actually correct information and not disinformation, misinformation. When we get into it, we're going to get into it in a bit. Before we start, I want to start off today's show with our sponsor, because we're not going to get back into it afterwards. And we do have a sponsor for today's show, and it is Enhanced People. On July 11th, Los Angeles, the world's strongest man, Thor Bjornsson. If you don't know who he is, I don't know where you've been. Everybody knows who Thor is. Goes for a world record deadlift at Enhanced Breakers. Now, most of us aren't pulling a world record, but the same team behind the Enhanced Games runs a telehealth arm with licensed clinicians, and they've built the daily routine Thor's Protocol is named after. It's called Thor's Protocol. Here's the idea. Instead of juggling separate prescriptions, it's 3 clinician-guided products bundled into one daily routine, each one prescribed individually after a clinician reviews your health questionnaire, laboratory results, medical history. Testosterone therapy, clinical, supervised, and personalized based on the patient's evaluation, laboratory results, and medical history. NAD+, which supports cellular energy metabolism and healthy NAD+ levels that naturally decline with age. And low-dose Tadalafil, a clinician-prescribed daily dose to support healthy blood flow. This isn't a supplement you throw in a cart. It's a prescription. You complete a short health questionnaire. You do blood work, and a licensed clinician decides if it's right for you. Labs and follow-up check-ins included. Eligibility is determined individually, and not everyone qualifies. That's the point. It's built for your body, your biology. It's not one size fits all. If you want to see whether you qualify, go to enhanced.com/Thorstack. That's enhanced.com/Thorstack. Check out your eligibility, and if prescribed, your medications can be shipped directly to your door. Enhanced.com/Thorstack. And now, people, I hear something in the backdrop. What's going on here? I hear something in the backdrop. I'm going to add myself back to the stream. The hearing has started. Let me bring this up here, and we're going to get into the day 3 of the
Mr. Robinson, good afternoon. And also for the record, the court recognizes the presence of victim representative, Ms. Erica Kirk. Good afternoon. First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during the proceedings will not be permitted to re-enter until the recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. And as you note, the microphones on your tables are turned off.
Statements. Let me just know if my audio is too loud or not loud enough compared to the native audio. I'm going to try not to talk over things. I might duck out in an hour and a half. I'll leave it playing if I do. and we'll have commentary throughout to the extent it doesn't interfere with the hearing.
You both could come forward, please, to the lectern. All right. Could you both state your names?
John Wilson, KSL Television.
Tess Crowley, Deseret News.
Good
I was on with
afternoon.
Jack Posobiec or
Could you state your roles for
human
today's
events
hearing?
earlier today. Did a good one.
Video recording and streaming of the proceedings.
I'm the pool still photographer.
All right. And have you both reviewed the court standing decorum order?
Yes.
Do you understand the...
Now, in the chat, I'm going to put on mute. We're just doing some preliminary stuff. Does everybody want me to pause if I have anything meaningful to say? Do we wait for breaks, which I don't know how often they're going to come? I may or may not defer to what the answer is in the chat, but let me know how you prefer to do this. If we pause it, we'll be behind schedule. And if I talk over it, people tend to complain. So let me know.
Requirements set forth in that order as they apply to the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom.
And let me just mute it. I won't pause it. Just to reiterate what I highlighted on human events with Jack Posobiec's show, but Jack Posobiec is there in person. He said that some of the footage you've seen of Tyler Robinson on campus is actually much clearer than what we're seeing on the internet. Preliminary hearing, people, this is not the stage of proof beyond a reasonable doubt. If people want to raise reasonable doubt as to whether or not it's Tyler in all of those videos, that will be at a trial. Right now, it's probable cause. Is it more likely than not that a crime has been committed by Tyler Robinson? If so, take it to trial.
Civil and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner.
Still doing the preliminary stuff. I want to bring this one up. This is pathological, by the way, or maybe you're of good faith when you say this, Sunny 2020. I'm not distracted. Nothing is on my mind any more than regular, but people like to do this to like, hey, that person's crazy. Don't listen to them. This is a technique to discredit someone's opinion by saying that they're hysterical or out of their mind or whatever. I'm perfectly normal. This day is actually better than most. But no, to answer your question, if it's sincere, I'm not disoriented. I don't know why you'd say that. Nothing else is on my mind any more than any day of the week. But this is a tactic that people use to say, he must be crazy. Don't listen to him anymore. Let's go back to the audio.
The rights and dignity of every person involved. Finally, I wish to note that this preliminary hearing is scheduled to conclude this Friday at 5 p.m. I raise this as simply a reminder for the parties, particularly given that we have now reached the midpoint of this week. I recognize and respect the constitutional rights of all parties. When this preliminary hearing was set, the court allocated a substantial amount of time for both sides to address the matters they consider necessary and appropriate for purposes of this proceeding. The standard at a preliminary hearing is probable cause. And with that in mind, I ask counsel to remain mindful of the time that remains and manage your time appropriately so each of you is able to fulfill your duties to your respective clients within the time frame that has been provided. And with that, I wish to inquire of a brief overview on what is anticipated from each party in order the court has a roadmap on how we are proceeding for the remainder of this preliminary hearing. First, turning to the state, and if you wouldn't mind coming forward, Mr. Grunander.
And by the way, I'll talk over now. This has been very long.
Thank you, Your Honor. We anticipate presenting evidence through Agent Brian Davis this afternoon. Sergeant Jennifer Faumina is also present in the courthouse and prepared to testify if we get to her today as well. Following her testimony, which we believe will carry into tomorrow, if we do get to her today, that will close the presentation of the evidence on the part of the state.
Thank you, Mr. Grunander. For defense.
Here's another classic one. Viva believes the Fed slop in Tyler case, but not the pipe bomb. Classic stupidity.
Good afternoon.
Tell me what I believe in this case.
Michael Berg for Mr. Robinson. Judge, we have two remaining witnesses, Miss Oliver from the ATF and Miss Carner also from the ATF.
I love it. I'd love for someone to
All
tell
right,
me what
and
they
to
think I
both
believe.
parties, thank you. I
Thank you.
appreciate that. Do both parties anticipate any issues concluding their case? Obviously, there's variables, cross-examination, and kind of the fog of war that happens in court proceedings, but any party anticipate issues concluding at or before Friday at 5 p.m.?
Not from the state.
Everybody should understand also, I think 5 days
Just
for
want
a
to highlight
preliminary
one
hearing
issue for the
is
court
already
because it may
exceptionally
be
long.
that the court wants to do some time management.
This
The
is so
state is going to proffer a video 1102, a video recorded 1102. We have provided the state, I want to say about a day and a half ago, with proposed redactions because we believe that portions of it are not admissible, even in a preliminary hearing. And the way we did that is we provided a transcript and then a redacted version of the transcript of the entire video recorded interview. It may be that the court wants to look at the proposed redactions not while court is in session, but during some other period of time,
All of
because
this-
the transcript of the video, which we prepared and we provided to the state, so the state could raise any concerns about the accuracy of the transcript. That's not an issue. The admissibility of portions of the video or the issue is about 20 pages, maybe 22 pages. So to use court time for the court to look at the proposed redactions may be an inefficient use of the time. I'm not saying when the court should do it. I'm just saying we may not want to do it between 9 and noon and 1 and 5 tomorrow or Friday. But it's going to come up today. And so the question will be, when does the court want to engage in the process of reviewing
Over
the
lunch.
22-page transcript that has proposed redactions? That's all.
I want
I
to bring this
appreciate
up.
the heads up. Mr. Gernander, do you wish to be heard?
Tyler is 1,000% a patsy. This is a sham. In what ways?
Your Honor, the state has received
or.
the
Eighth or.
proposed redactions, and we are prepared to address them when that time comes. However, we do intend on presenting testimony through Mr. Davis, through Agent Davis, and when we get to that point, when it's ripe for discussion, we can address the matter with the court. That would be our preference.
All right. Well, I'll address it as it comes. And to the defense, with the remaining time, do you feel confident that it is sufficient to?
Let me just put on pause here. They're talking about time. Tyler's a patsy 1,000%. This goes to the same thing of a false flag, which has a variety of meanings on a spectrum. It didn't happen. It did happen, but it wasn't the person who did it. It happened, but not to the extent to which it's being said. Patsy, you think he has nothing to do with this? He's involved in a scheme, or he's just not the one that pulled the trigger, or he's the one that pulled the trigger, but he's part of a broader conspiracy. How do you mean, Patsy?
Just to address an issue that's come up and we expect to come up as we enter the second half of this preliminary hearing regarding the admission of exhibits. Under Rule 104A, the court must decide preliminary questions about whether the witness is qualified or a privilege exists or evidence is admitted.
We'll put it on pause here. They're going to talk about the admissibility. I'm not sure if the admissibility on this is how they obtained it or whether it's unduly prejudicial and not sufficiently probative. We'll get to that later. The DNA issue is the one that's causing a lot of confusion because there was some confusion yesterday. And without getting into the fights that I've been having on the internet over the bar of evidence for a preliminary hearing and what you're seeing here, oh, there's no way it's him in that grainy video. How do you know? Reasonable doubt versus probable cause. Yesterday, the DNA expert made a mistake where she confounded the proportion of minority versus majority DNA that was found on the screwdriver and the towel, and that it's shared DNA, but in the proportion of 11% twigs and 5% twigs. I think it's the towel and the screwdriver respectively. That may be reasonable doubt as to whether or not it could have been twigs on the roof and not Tyler Robinson, but people were saying it was 89 and 95% the DNA of twigs, which is just flat out wrong, and that was corrected yesterday, and anybody still repeating that, treat them with a great degree of skepticism.
The court has held that rules of evidence do not apply to evidence used to establish foundation for admission of other evidence. It's a quote from paragraph 33. So the point is, foundational rulings on admissibility can consider evidence that is not in and of itself admissible. That's proper. The second point is the courts of appeals recognize a presumption that the court considers when acting in its fact-finding role only the admissible evidence and disregards any inadmissible evidence. Most commonly,
Whoa.
What the heck
I
is
just built
this?
a budgeting app in Base 44.
Running ads?
Guys,
Why don't you have ad
Nina just
blocker,
built-
Viva, you
and it can have
loser?
dual inferences. State v. Adams was one of those cases. That's 2011 UT App 163. And what it means is we know that a fact finder is not tainted by the judge's role as a gatekeeper.
Okay, forget this one. We'll come back to this when they do it. There's also the issue that nobody could identify Tyler Robinson from the videos. It's all grainy, yada, yada, yada. File 404 says Tyler's own mother identified him in one of the videos. I guess his parents are also on the conspiracy. Everybody's in. It depends what you mean by the conspiracy here. And if you want to say he took a shot, but it wasn't the shot that killed him, they had a sniper further down. I was talking with Brett Weinstein earlier today, and I can disclose this because he allowed me to disclose it. And Brett and I are going to probably do a podcast in the near future. And I'm not saying this because I spoke with Brett, and I'm not trying to stroke his ego. Brett is one of the sharpest minds on the internet. Whether you agree with everything he says or not, he's methodical, and the way he thinks is what's important. And you can agree or disagree with the conclusions that he comes to. And we were talking, and I said, there's a number of theories out there. And he says, no, there are hypotheses out there, not theories. And the theories are the ones that withstand the scrutiny, testing, or contradicting or negating the hypothesis. And so people come out and say, it's not a theory that the microphone exploded. It's a hypothesis, and it's negated by the fact that it's logistically virtually impossible. I'm going to be on with, we're going to figure out how we do this with Brett Weinstein. But, what he said is a very interesting thing, is that people can put out hypotheses that are more or less tenable, more or less idiotic. And at the end of the day, the theory is the last hypothesis that has withstood the scrutiny and not been falsified. And so the parents are in on it. All right. Tyler didn't pull the trigger. Someone else did from a different distance. That's, as of yet, not falsified. But it's at least not as absurd if you want to think that Tyler's a patsy and didn't actually pull the trigger, though he thought he was because he's been brainwashed online. It's a little bit less insane of a theory than, I don't know, space lasers or exploding microphones. But it was a very interesting thing that Brett told me, and I won't soon forget it. A thesis. No.
And can distinguish between admissible evidence.
Okay, we're still on the admissibility. You put forward a thesis, and if it withstands, the matter of the fact is the mother did recognize Tyler from the video, so it can't be that grainy unless the mother misidentified her son. If her son's a total innocent patsy, we haven't heard that from the parents like we've heard it from the family of Brian Cole Jr., and there certainly is at least circumstantial evidence, prima facie, indicating Tyler is the one who did it from a probable cause perspective. And if you think it's all bunk, it'll come out at trial when the burden of evidence is much higher.
Because of the Supreme Court's ruling in Archuleta concerning the availability to the public of exhibits from a preliminary hearing, which of course is a fact-specific inquiry by this court, we will continue to raise concerns about our client's right to a fair trial when we think it's appropriate, and the court will make the rulings it makes. That's all I want to say.
All right.
By the way, I do have a list.
Right, to both parties, the standing request remains when you are moving a piece of evidence into to the record. I ask 3 steps: admissibility, to admit it, to be published in the courtroom, and then to be published on that screen. And I'm going to have the screen adjusted slightly because if it's published, I want it to be meaningfully able to be viewed. And I noticed somebody sent me a screenshot that angle creates an interesting
blur
angle that kind of distorts it. So in the interest of, if we're going to be transparent, it should be viewable transparent. So we'll adjust that screen briefly, but please address those 3 issues. And I understand one side or the other might say, well, we agree or we don't agree, period. But please, I'm trying before us is a clean and clear record. So if you would do that, the court would appreciate that. All right. Anything further?
And by the way, so I do have a list.
All right.
If it sounds like I'm saying
the court acknowledges that the exclusionary rule is in effect at this time. Any witness who is subject to exclusion should be excused from the courtroom. I will leave it to the parties to monitor the courtroom to ensure that compliance is adhered to. With that, turning to the state, you may call your next witness.
Excluding the witness so that
while the parties are moving forward, go ahead and adjust it, and let's put a sample image of Something has nothing to do with this case on the screen.
Judge, that's another issue. I don't know that it is projecting yet. And I don't know if we need
We'll talk about this one. 30-06 is taking his head off every
Is it not
time.
projecting on the monitors?
All right. A 30-06 didn't take off
Okay.
Martin Luther King's head.
Technology is challenging us again.
Hold on, while we figure this out. Does a 30-06 ever misfire? Do you ever have like a dead round where you shoot it, nothing happens? Does it ever misfire? Like the idea that all 30-06s, irrespective of age, condition, maintenance, treatment, whatever, all perform exactly the same. And as anomalous as it might be, I was going to show the video of those two bullets that struck each other allegedly mid-flight back in World War I. As anomalous as it might be, if you don't believe it was a 30-06, what do you think it was? But to say something's impossible when many, many experts out there say bullets have minds of their own and not all 30-06 perform the same way, oversimplification to dismiss what is, as unlikely as you might think it is, still a possibility that has not been falsified. Are we still talking about the TV angle right now? Who does the judge remind me of?
Where would that TV go?
We're still talking about the angle of the TV. It's just, half of court is spent wasting time on like technical
If
stuff.
that doesn't address any security issues, let's do that. I just want to make it easy. That way that TV can be more flat and it's not a distorted view.
And it also
not
makes you
just
weirder things.
there in concept.
Martin Luther King.
All right.
If
Yeah,
you
let's go
believe
ahead and
the
do
narrative
that.
was
How are
shot
the
with
monitors
30-06.
looking? Nothing?
30-06 was used in World War II. I guarantee you there were multiple people killed didn't have an exit wound. Who knows?
I see.
The
Could I have someone with your laptop plug in so we can test, so we can check if it's receiving?
All right, let's put this on pause while we deal with 15 years I practiced. You would have a day at court. 15 years I practiced. You would have a day at court. I would say more than 20% of it is just wasted. And for someone with ADHD who enjoys finishing people's sentences before they can finish them when I know what they're going to say, you have to sit here and listen to them futz around over a television? We still on the television?
All right, and on the screen
We're still on the
monitor
television.
here, it looks like something came up. All right, we'll just hope that the monitor for the witness works as well.
All right.
All right, so we're ready to go?
How many minutes we've been watching for, and we haven't yet gotten to the substance of this preliminary?
Just bring it in and go ahead and we'll get started. And how much time is needed for that? Well, let's go ahead and proceed. And then when we take a break, then we can do that. But for now, the media, if you can see that TV, if you have any problems, please let me know. And we're going to bring in that.
Put this on mute for 1 second. Yes, it's extremely easy to reload ammunition. Again, tell me you're a hunter shooter without tell me you're not a hunter shooter. Listen to people who actually live it and know what they are talking about. I don't think you're talking to me, Swampy Rumbles, because I do know someone who loads his own ammunition, and you can have hot rounds or maybe even improperly loaded rounds. Let's get to the show here.
All right, Agent, if you wouldn't mind having a seat. To your left is a water bottle. And after you're seated, you'll have to adjust that microphone, pull it down, and then pull it toward you to ensure that it is.
You cannot predict what a bullet will do,
Picking up
and
your
you
voice
can't
and have a
comment
good
on
record.
what the bullet did without knowing the condition of that bullet, period. We have Kelsey Grammer on the stage.
All right.
I want to briefly go over your experience as a law enforcement officer generally. These were you with prior to SBI?
So Department of Public Safety, I've been a state trooper for 8 years, 18 years with SBI, and 1 year with the Utah Transit Authority Police.
We've heard talk from other officers about POST. What is POST?
That's Peace Officer Standards and Training.
Did you complete that?
I did.
What year did you complete that?
1999.
We must be about the same.
Is that a type of certification that you hold?
Yeah, it's a statewide certification that any peace officer in the state of Utah, local, state, county, all go through to become a certified peace or police officer.
Has that certification lapsed or been any gaps in that time since you received it in 1999?
Nope, it's been constant since then.
I want to talk about a bit about your training and experience within law enforcement. What roles have you had at SBI?
I began as a alcohol enforcement team. We did covert and overt operations. I was assigned to an ATF, the PSN task force,
What was this guy's
focusing
first
on
name? His last name is
violent felons with guns and drugs. I was on a FBI task force, Safe Streets. It was a gang violent crime task force. I was on the U.S. Marshals Fugitive Apprehension Team task force. I've been on several different OICI protocol teams, Officer Involved Critical Incident teams around the state of Utah and within SBI. I've been on dozens of those scenes. And within major crimes of SBI, I've been, we've worked a variety of firearm crimes, white collar crime, fraud. I was also on a task force with a FBI public corruptions task force as well.
Was that all on the job training, or did you receive specific training or conferences, things like that?
Yeah, throughout the years, various trainings, conferences for in all those capacities over the years.
You mentioned you've been a part of homicide.
So we consult with agencies around the state of Utah, and I've probably consulted on over 50 of those as well in various capacities and roles.
Have you received training specific to homicide investigations?
Yes, I have.
What types of things have you been trained on in that regard?
Just several different times, week-long course training conferences on homicide, from case studies to how to manage a case. Also, I've been on several trainings with like crime scene investigation.
I'm trying to find a synopsis of what
FARO certified. It's a 3D
to.
FARO scan of crime scenes.
What's a FARO scan?
It's a 3D laser imaging that's used pretty commonly on crime scenes. It just accurately documents crime scenes. And I've been on, I'm I've been certified as a forensic interview and the forensic interview technique with more child victims. So just various trainings like that.
You mentioned currently you're a part of the cold case team within SBI?
Cold case, not cult case. People.
Have you been assigned as part of the investigation into the homicide of Charlie Kirk?
Yes.
And what is your role? Do you have a specific role in that investigation?
Yes, I was assigned to be a case agent along with Agent Dave Hull.
What does it mean to be a case agent?
Essentially, you manage the case, responsible for it. Ultimately, you direct
overall timeline,
the cases as you go along. You
to the crime, family,
make assignments
That's the big one.
as needed.
And
Ultimately, everything comes back to you, like in the form of reports, evidence, and such. And then ultimately, you screen that case, if applicable, to the appropriate county attorney or DA.
You mentioned that you are a co-case agent or were with Agent Hull. Is it typical to have two case agents on a case? He's been involved in the investigation of this case.
Yes.
Who has been designated as the primary investigative agency?
The State Bureau of Investigation is the primary investigating agency. I
know there are probably several or dozens, but what other agencies have you been working with?
FBI, ATF as well, several local state agencies, UVU Police, Orem Police, Utah County Sheriff, Washington County Sheriff, St. George PD, most of all the agencies within Utah County and even others outside of the county. So we've worked with a lot of agencies with this case. It was a pretty large scale investigation.
You mentioned ATF. What does that stand for?
Alcohol, tobacco, firearms.
All right. I know a lot about so as a case agent, have you been in court during this preliminary hearing?
Goodness, can you just get to the substance? He's been doing this for 29 years.
We've talked a lot about the events of September 10th of 2025. I want to direct your attention to September 11th, 2025. Do you remember that day?
I do.
What happened on that day in relation to your investigation?
I spent the day at the command post with various assignments. 8 p.m., I believe, of the 11th. I received a phone call from Sergeant L. Schulz requesting that I travel to St. George.
Who is Sergeant Elsholz? What agency is Sergeant Elsholz with?
With SBI.
And he requested that you travel to St. George?
Correct.
What was the reason stated for that?
We received information that an individual was turning himself in, or was going to turn himself in to police in regard to his involvement with the incident, the shooting on UVU campus.
And I'm sorry, what time did you get that information, that call?
About 8:30 p.m. And we were flown down on a fixed-wing aircraft. It was Sergeant Elsholz, was Agent Folger with FBI, Agent Anderson with FBI, Ryan McBride and myself, and the two pilots.
And who is Ryan McBride?
With the Utah County Attorney's Office.
What time did you arrive in St. George?
We landed probably about 11:30 p.m. at the St. George Airport.
And again, this would be the evening of September 11th,
The day after
2025?
the assassination. Oh my goodness, is that okay?
This game.
Does ad blocker
You're not
actually just
ready.
block the
Transported via ground to the Washington County Sheriff's Department.
Did you coordinate at that time with any other law enforcement agencies down in southern Utah?
Oh, we did.
You did?
We did, yeah.
What other agencies?
Well, with FBI, as we were traveling, and then along with mainly the Washington County Sheriff's Department, we also have agents with an SBI assigned to the southern Utah area. So working with them as well, just making plans and coordinating resources and manpower and personnel.
And you stated you went to the Washington County Sheriff's Office.
Yes.
What time did you arrive there?
Probably somewhere close to midnight, maybe just a little bit before midnight of the 11th.
What happened next?
So we met several other investigators, agents, and detectives there, along with some other prosecutors. There were some federal prosecutors as well that were present. And from there, we began kind of making plans, determining how to handle the situation there.
Did you?
I did.
And where was that person at the time?
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the soft interview rooms. That room was equipped with audio told. He arrived there about 9 p.m. that evening.
And was he with anybody else?
He had been, he'd come there with his parents and a family friend.
Did you speak with this individual that we've been talking about?
Yes, I did.
Who was it?
Did you get his name?
Yes, we obtained his name and date of birth.
What was his name?
Tyler Robinson.
Did he tell you that himself?
He did.
You mentioned other individuals came there with him. And then you also said that you had kind of coordinated with the team of law enforcement officers that were there. Were those other individuals spoken with by law enforcement?
They were.
Let's go through them.
I'm going to screenshot a bunch of questions that we're going to come back to.
How did that happen? Who was spoken to first of the other individuals?
Get your questions out fast.
So Tyler's mother was interviewed by SBI agent Holgreen and FBI agent Cox. And then kind of simultaneously, his father was being interviewed by SBI agent Terry and FBI agent Smith. And also at that time, the family friend Mike Mitchell was interviewed by...
These interviews were being conducted simultaneously?
Yes.
Were you part of the interview with either of Tyler's parents?
Yes. Yes, myself and Agent Folger. Did I misspeak earlier? Myself and Agent Folger interviewed the mother.
Okay, so
all right. Let's make sure the record's clear on that. So Agent Folger, what agency is he with?
With FBI.
And yourself interviewed Tyler's mother?
Yes, that's correct.
I just want to make sure the record's clear. Who interviewed Tyler's father?
Yeah, I think I might have misspoke. It was Agent Holgreen, Agent Cox that met with his father.
And then who detained at that time?
Yes, he was.
Detained but not arrested. So
was he formally arrested at that time?
Yeah, following, after all the interviews were completed, when we talked to everybody, then he was formally arrested at that time.
And Mirandized.
And I'm going to come back to that in a second. Excuse me, where did the arrest take place?
At the Washington County Sheriff's Office.
The question of when he was Mirandized is important. The question of when he was taken into custody is important as it relates to.
And what date did that happen on?
Would have been September 12th. It was about 4 a.m., I believe, of September 12th.
All right, I want to show just on your screen, not for public yet, what's been marked for identification as State's Exhibit 15.
So, again, this is
Let me know when
nothing
you're
to do
able
with
to
however
see
you
that.
feel about the case. The issue and the conspiracy point is, when did Tyler get taken into custody? When was he Mirandized? And when did he allegedly send the Discord messages and the text messages? Because some people are saying he was already in custody.
Before I ask you about that, did you have an opportunity to, you stated that you observed Mr. Robinson at Washington County Sheriff's Office, is that right?
Yes, that's correct.
Your Honor, can I have a moment with Ms. Hunt?
So the question is, one of the questions is, the time at which Tyler allegedly sent the text messages, the Discord chats, when he was detained, taken into custody,
That may
when he
happen a
was
couple more
arrested,
times as we go through exhibits.
and when he was
because of
formally Mirandized.
agreements and disagreements.
Thank you for the heads up.
At Washington County Sheriff's Office, where you initially observed Mr. Robinson, you stated that he was in a room. Is that room equipped with video recording?
Yes, it is.
Is that standard practice for a facility like that to have video recording
Yes, it
in
is.
such a room?
Yes, very, very common.
Have you reviewed that video?
I have.
And in your review of that video, does it fairly and accurately depict?
Mr. Robinson was seated and waiting.
State moves to admit Exhibit 15.
Ms. Hunt, and the other two steps, what's your request?
We would ask to admit it into evidence. We have, defense counsel and I have agreed upon, redaction of the video. And I would ask to publish it both to the courtroom and to the media.
Mr. Novak?
It's silent, correct? Ms. Hunt?
Yes.
Yes, Your Honor, Ms. Hunt is correct. The state had originally proposed a longer image with audio, and we've agreed to a shorter image without audio. And so.
Okay, so what is.
Correct? Yeah. So we're fine with all three steps as to this exhibit.
All right. Does the state wish to review this to make sure that what's queued up comports with what you believe?
Right now,
If
Ms.
not, we
Hunt
can move
is the
forward. I just want
prosecutor.
to allow all parties the opportunity to double check.
Let me just confer with my.
Is it not suspicious that they dug up the dirt within 4 days after via emergency paving request? I don't know what the proper protocol is, if there is a standard protocol in terms of biohazards to be left open. Did they do all the analysis that they needed to do?
It has no audio, so we would like to admit and publish it at this time.
Okay, now they're
All
just
right,
going to prove that they had him in custody at
Exhibit
that time.
15 is admitted pursuant to discussion and may be published in the courtroom and may be recorded or.
You don't have to
Assume that
reiterate
we don't
them.
need to start over with that today.
Thank you. I appreciate that. I note the standing objection by defense as previously made, and that objection is overruled, and this exhibit is admitted.
And in this case, it wouldn't be the 1102 issues, it would be the electronic media coverage of the proceeding.
Thank you for that clarification, Mr. Novak. I appreciate that. All right, with that, to the media, can you view that screen okay? All right.
Yeah, okay, so this
All right,
looks like.
State's Exhibit 15 may be played.
Look at my gray hair. Holy cows. So much gray hair.
Okay, so that looks
And
like Tyler
Agent
Robinson
Davis, who are
wearing
we
the clothing
seeing here?
that he
That's
was wearing.
Tyler Robinson.
And although we are watching it on video, what is he wearing at this time?
He's working a dark colored baseball cap with I believe it's like maybe the Hurley symbol on it.
So this is
like
how
a
we're
white
going to
symbol
connect
on
it to the
front.
video
It's
that
a
they had from the day
burgundy
before.
short sleeve shirt with no
Probable cause,
graphics.
people.
It's blue jeans and gray and white tennis shoes. I believe they're Converse style tennis shoes.
Thank you. Was Mr. Robinson, you stated that he was arrested in the early hours of September 12th, is that right?
Yes, that's correct.
Did he remain in Washington County Sheriff's Office, or was he taken somewhere else?
No, he was transported from there to the Utah County Jail.
That's
Prior to being transported to the Utah County Jail, was any, I guess, personal property taken from him, clothing, anything like that?
The only thing that was, so prior to like our arriving to the St. George, to the Washington County Sheriff's Office, his cell phone was.
Were any personal items taken from him?
Yes, they were.
And what were those?
After a search warrant was granted, his clothing was recovered, along with buccle swabs to collect his DNA.
Ask if they DNA and maybe
major case prints, which is fingerprints. 7 a.m. on the 12th, September 12th, and he was formally booked in at about 8 a.m. of that morning, and then I was the booking officer.
What does it mean to be the booking officer?
I filled out the necessary paperwork essentially with the jail, which gives the individuals personal identification of the charges, the probable cause statement, and then it's signed and submitted to the system.
All right, I want to talk a bit about search warrants, some of the search warrants that were executed in this case. As part of the investigation, were search warrants obtained specifically for areas in southern Utah?
Yes, they were.
And obviously do not give me exact addresses, but generally for what locations?
Tyler Robinson.
It was the residence of Tyler Robinson and the residence of his parents.
Were those warrants executed?
They were.
By whom?
The residence of Tyler Robinson was a team led by Sergeant Famawina with SBI, along with the Utah State Crime Lab. And the residence of his parents was a team led by the FBI, their evidence response team.
Are you aware of what date or dates, if applicable, those warrants were executed?
Yeah, September 12th. I believe Tyler's residence, they started the search warrant about 8 o'clock in the morning. And then his parents' residence, they started about 4 p.m. Of September 12th.
So to be clear, you've stated who was involved in executing those warrants. Were you physically present for the execution of either of those warrants?
No, I was not.
Aware of whether Mr. Robinson lived with anyone else at that residence?
Yes, I'm aware he lived.
Yes.
Do you know who that was?
Lance Twiggs.
And we won't get too into it right now. We'll cover this with Sergeant Faumina, but did you receive information from officers involved in those execution of those warrants about what, if anything, had been found?
Yes, I did.
Who was that family friend?
His name was Mike Mitchell.
And who is he in relation to the Robinsons?
So he's a family friend, a good family friend.
He's the sheriff.
And what was his involvement here?
So he helped facilitate working with Tyler and his parents, with the sheriff's department for Tyler to turn himself in.
And I believe you mentioned previously that law enforcement conducted an interview with Mr. Mitchell.
They did.
Remind us when that interview occurred.
So that was the early morning hours of September 12th at the Washington County Sheriff's Department.
And I know you've already stated, but remind me who was present for that interview.
Okay.
That one was Agent Terry and Agent Smith.
A statement like PSYOP means nothing unless you elaborate. On
Terry's with SBI and Smith is with FBI.
Are you aware if a second interaction or statement was collected from Mr. Mitchell?
Yes, it was.
When did that happen?
It was March 31st of this year.
Who was present at that time?
It was Ryan McBride, Chad Grunander, Kimberly Durfler, and Agent Chris Terry with SBI.
I'm just trying to figure out where she's going.
You mentioned Ryan McBride, Chad Grunander, and Kimberly Durfler. What office do they work for?
The Utah County Attorney's Office.
And you mentioned Agent Chris Terry.
Yes.
So you were not present for this collection of this statement.
No, I was not.
Have you communicated with Agent Chris Terry about how this happened?
Yes, I have.
How did this happen?
Oh, there might be an objection.
So all those individuals met with Mike Mitchell at it was the St. George, well, it was at the St. George court office, courthouse there. They met and discussed briefly. I was going to kind of talk generally about the situation. From there, Mr. Mitchell was given a handwritten 1102 paper statement, and he left the room, went into a separate office by himself, was there for about an hour where he hand wrote a statement, filled the statement out.
If you know.
There's an admission or warning given on those forms that states that the information you're giving is true and accurate to the best of your knowledge. That any false statement that is given or maybe given would be punishable by a Class A misdemeanor.
Under Utah criminal proceedings.
Aside from that being written on the form, are you aware if this admonition was discussed with Mr. Mitchell?
It was.
Do you know by whom?
Yeah, Ryan McBride provided that admonition to him.
And you stated that Mr. Mitchell then went into a separate room for about an hour and wrote his statement down?
Correct.
Did anyone, including prosecutors or law enforcement, direct him what to say?
Foundation objection. Personal knowledge.
Would you like to respond, Ms. Hunt?
I can lay a little more foundation.
All right, so I'll sustain the objection for now, and Ms. Hunt is moving forward with laying more foundation.
1102.
You discussed with Agent Chris Terry about how this statement was obtained?
Yes.
Did he mention anything to you about anyone directing Mr. Mitchell about what to say or what to include in the form?
No, I spoke to him personally and reviewed his report also.
It allows the prosecution to use
This is the type of
hearsay.
faceless animated videos that helped us grow our channel 10
I'm gonna
times in
switch over to Rumble
2025.
Premium,
And we created this
as soon
video
as we
in
have a
under
break.
5 minutes with
So we stop
TuneB
getting these
AI.
garbage ads.
Just type.
Sorry.
Let me know when you see that on your screen.
So it allows a prosecution to use reliable hearsay from a witness at a preliminary
What
hearing
is
instead of
that?
requiring them to appear.
This is the written 1102 statement that was provided by Mr. Mike Mitchell.
Your Honor, may I have a minute with Ms. Hunt for the same purpose?
All right, so 1102, I guess that means that they're going to have the statement in lieu of the testimony.
And how do you know that?
I've reviewed it. I reviewed it in its original. As soon as it came to us, I've seen it prior. So.
And Kimberly, if I can have you slowly scroll down.
Okay, are we going to see this? No, I'm not going to. I'm going to leave this running, incidentally, even after I leave, if I have to leave before this hearing ends. So you'll get this. And
Sorry,
then
Judge, if I can just have a moment.
I'll do a summary a little later on. So going back to the soil, 10 inches or a foot of soil being removed and they paved over it, depending on if that deviates from protocol as relates to disposal of biohazards after a crime scene has been sufficiently or adequately investigated, if it doesn't deviate from standard protocol, then you can find it weird or whatever, it's protocol. If it does deviate from protocol, then you could reasonably say it's suspicious. And then the question is, what do you posit is the reason for which they would do it? What are they hiding? What are they concealing? Are they hiding the fact that it wasn't Charlie Kirk's blood? Are they hiding the fact or potentially digging up and disposing of the fact that another potentially...
I apologize, Your Honor. I
DNA
misspoke. It's not
was there.
14.1. It's just Exhibit 14.
Okay.
So if we can place that again on the screen for the witness only. Yes. And sorry, we had been scrolling through that. Do you recognize that?
I do.
Does it depict, is it fair and accurate from what you remember?
Yeah, with the exception of the redactions, yes, it's fair and accurate.
And Judge, I'll make a record. Defense counsel and I have stipulated on the redactions that are present. I would move for its admission, states Exhibit 14, into evidence, but we do not wish to publish it either to the courtroom gallery or the cameras.
All right, could I have a copy of it? What I have is the unredacted version. So I want to review it before I make that decision.
it appears to be deviating from standard protocol to pave over a crime scene 4 days after. And then the question is only going to be, or it's the reasonable question is, what conspiracy does that, is that hiding? What element is it hiding? Is people are going to say, well, that proves that Charlie Kirk wasn't murdered. That'll be crazy. If it's to potentially hide the implication of other players, that'll be less crazy. If it's to undermine whether or not Tyler Robinson took the shot, allegedly, that's, arguably connected. But yeah, we can agree that in any given case, not everything is going to be done properly according to protocol, and there may be good conspiracy theory reasons as to why it might have been done. I'm trying to find the conventional steelman explanation for why that was done. Let me see if we cannot find that in real time. And I'm going to get to some questions in a second.
All right, I've had a chance to review State's Exhibit 14 and noting the standing objections by defense.
Got another one. He's getting jealous.
Concerning 1102s, the court accepts into evidence State's Exhibit 14 and pursuant to the parties is not published.
Thank you, Judge. All right, I want to move on to another topic, to the scene at UVU on September 10th, that a bullet was found on a roof. Do you remember that testimony?
I do.
Do you have knowledge about that bullet, what that is about?
Yes, I do.
That it was found there?
I reviewed the agent's report that found that, documented it, and collected it.
What agent was that?
It was Agent Ben Schneider with SBI.
Are you aware of where the computer science building is on campus?
Yes, yes.
Can you explain generally where that is located?
Yeah, from where the LOSI building is, it's a building directly kind of south and east of there, from the LOSI.
Southeast from the LOSI building. Where is it in connection to the auditorium section that we've been talking about where Mr. Kirk was stationed?
It's east of there. East and a little bit south, and mostly east.
Would there have been, from that roof of the computer science building, to your knowledge, would there have been a line of sight to Mr. Kirk's tent?
No, not according to the agent. Agent Ben Schneider, there was not a line of sight from there to where the tent was, where Mr. Kirk was.
Did you learn from Agent Snyder what caliber that bullet was?
Yes, I did.
And what was that?
It was a .223 caliber.
What is a live round?
It's a round that had not been fired, so it still had the projectile, and it was a fully functional bullet with ammunition with the bullet.
Did you learn if this .223 bullet found in your science building was a live round?
Yes.
And how do you know that?
It was still intact. Still had the primer had not been.
That's what I picked up.
It was not dented, not been fired. It still had the bullet projectile in the end.
So is it
still sealed.
Is it a .223 or is it?
Did you observe this bullet personally, or is this information you're getting from Agent Snyder?
From Agent Ben Schneider.
Is anybody else confused as to this particular?
All right, turning to a different topic. And Judge, I'm aware that there are going to be some objections about this that we'll have to address, but I just want to lay a little bit of foundation first before we get there. You've mentioned him already. Are you familiar with the Nishan?
He was.
How many times?
2 times.
When was the first time?
The first time was the early morning hours of September 12th, and that occurred at St. George Police Department.
So we've heard of several people coming in and being spoken with at Washington County Sheriff's Office.
Correct.
Mr. Twiggs was spoken with at St. George PD.
Correct.
So the .223 apparently.
Do you know who was present for that interview?
Found at a different
It was FBI agents Larson and Agent Ling.
Okay.
Are you aware of Mr. Twiggs' buccal swab was taken at that time?
I don't recall happening there. I believe it happened later. I'd have to, but it did occur. That was obtained from him.
Okay. But you're not sure if it happened on the 12th?
I don't recall if it was there or later at his residence, but
ultimately, a buckle swab was obtained from Mr. Twiggs?
yes, it was.
A buckle.
Do you know if his phone was taken from him?
Twigs.
It was.
His cell
When
was taken from
did that happen?
So it was during that interview with FBI at St. George Police Department.
What
They
time?
conducted an interview of him, and then he provided his phone. He did it voluntarily also, provided it to those agents.
And that would have been on September 12th, 2025?
Correct.
You mentioned a second interview of Mr. Twiggs, please.
April 20th of this year.
April.
Where was that?
Happened at the Utah County Attorney's Office.
Who was present at that second interview?
It was Mr. Twiggs with his attorney, Jill Cottrell. It was Lauren Hunt, Sam Peed with the U.S. Attorney's Office, Ryan McBride, Sergeant L. Schulz, well, now it's Lieutenant L. Schulz, and myself.
We've talked about 2 interviews of Mr. Twiggs, one on the morning of September 12th, 2025, second on April 20th, 2026. Are you aware if both of those interviews were immunity means?
Yes.
What does it mean?
Yeah, well, better be.
It's a letter that the use of immunity is essentially giving the individual during the limited time of their statement, they're given
provides in the statement,
immunity from
but not
statements
blanket.
that are made in regard to an incident. But it does not preclude them from prosecution.
If they discover the information.
From evidence that would be known or found then or later outside of that interview. It just gives them that limited immunity during the type of the interview.
That particular.
Okay, so for any statements made during the interview, they're given immunity for that, but they're not generally prohibited from being potentially prosecuted outside of that interview. Is that fair?
That's my understanding.
Apparently, it's a buccal swab, not a buckle swab.
Was Mr. Twiggs given use immunity?
Yes, he was.
By what offices?
The Utah County
DNA.
Attorney's Office, as well as the United States Attorney's Office.
You mentioned that both of Mr. Twiggs' interviews were recorded. Have you reviewed those recordings?
Yes, I have.
Do they fairly and accurately depict those interviews?
Yes, they do.
It's a buccal swab. She's reading notes and probably reading a buckle swab.
We've talked about 1102
closed for like
statements.
fire
We've talked about a form, and you talked about that there's an admonition on there that warns that if false statements are given pursuant to 1102, then that person may be subject to a Class A misdemeanor. Is that fair?
Yes, that's correct.
Was a similar admonition given to Mr. Twiggs during his second or before his second interview on April 20th?
The County Attorney's Office.
And again, you were present for that interview.
I was.
Did Mr. Twiggs say that he understood that admonition?
He did. Yep. Yes.
Was he told that the April 20th, 2026 interview was being taken in lieu of him having to come and testify at the preliminary hearing?
Yes, it was. Yes, he was.
All right. I do have, I guess, I understand that they
want the guy to come
suggesting
in person.
Redactions to the video. I have some procedural objections first. And if Your Honor sustains those, I think it may make the substance of the statements or the objections or the redactions that defense is proposing moot. So I'm wondering if Your Honor will entertain my responses procedurally first before we get into the substance of what defense is objecting to. Does that make sense?
Apparently the official
Yes,
pronunciation is
if you want to move it, because right now nothing's before me.
Yes. Well, what I want to move, so defense is proposed about a day and a half ago. They created a transcript. Mr. Novak has proffered this earlier to Your Honor. On April, and I'll give you a little more proffer. On April 28th, 2026, the Utah County Attorney's Office provided this recorded 1102 statement of Mr. Twiggs to defense counsel.
This is what they were
They
objecting
have
about.
acknowledged the receipt and mentioned the recorded statement at previous hearings. In fact, they even filed a brief that Your Honor has decided about whether 1102 can be applicable to Mr. Twiggs at this hearing, which Your Honor has ruled upon. The defense team, and it had significant redactions that they were suggesting. It was about a 21-page transcript, and their suggested redactions are approximately 11 pages of it. In total, redactions appear on 16 of the 21 pages.
Okay, so remember they objected to
my procedural objections to
hearsay
this are that
from
this is
Twiggs. Now they want to redact a portion
essentially by
of the statement.
surprise. We were already a day into the preliminary hearing. Defense counsel had been aware since at least April 28th, 2026, when of it or propose any redactions that they wished. And yeah, frankly, it's by surprise, and it's at this point disrupting the hearing. It's not. I did mention that defense prepared a transcript of this recorded interview, how the state intended to present it, and how we have given it in discovery to defense is it's a video, audio and visual.
What's the reason for
Making
the objection?
redactions to that is not as simple as a transcript where you can just, block out sections of the text. So it's far more complicated than that to edit or redact portions of the video at this time. So we would object procedurally, basically on the timeliness of it, that they had an opportunity to make these objections if they had them at the time when the 1102 issue in regards to Lance Twiggs was briefed and decided by Your Honor. They did not do that or raise the issue at this time. And so we would object just procedurally on those grounds.
We heard it. What's the basis of their objection?
Additionally, the remedy requested, which I'm assuming is that we make redactions to the video or present it as a transcript rather than a video, is disproportionate. Even assuming if there are isolated statements that the court would not ultimately consider, again, as Mr. McBride pointed out, and as Your Honor has stated throughout this hearing, this is a preliminary hearing to the court. It's not to the jury.
Writing a book is hard.
Oh my goodness, you want to talk about ads? Okay,
Knowing if it's good, even harder. Neat
where's my
manuscript
screen?
analysis.
Skip this
It
crap.
gives
Give Your Honor that
talking
authority and presumption that judges are able to
The admissibility of hearsay
basically
ordinarily
make the difference
in front of a
between
grand jury, there wouldn't even be an
what's
adversarial
admissible evidence and
contestation.
disregard what may not be at a preliminary hearing or even at a bench trial. State v. Adams is one of those cases. If Your Honor wants the citation, again, I'm happy to give it. Rosecrans, 2024 UT
That
App
was from the great
128.
Gildenstein versus Rosencrantz.
And those cases all stand for the notion that essentially judges, and this is to quote from Rosecrans, judges are not subject to many of the same concerns about prejudices and improper influences as jurors.
Yeah, but that's a preliminary hearing too.
Again, procedurally, the remedy asking us to now, in the middle of a week-long preliminary hearing of which everyone was aware, edit or alter or redact portions of this video recording 1102, that remedy is disproportionate. If there are any potentially objectionable statements within that, Your Honor has the ability to disregard those. And so we would prefer not to get into the substance and argue each statement line by line. And we would prefer to just move for its admission and have the court use its discretion as a judge to take what's proper versus improper, disregard anything the court might find improper. If we would like to move into substantive objections, then we're happy to, but if the court can rule on those procedural objections first, it may make any substantive objections moot.
All right, so you're moving into evidence states exhibit 16.
Yeah, that's going to be the 1102
Yes.
from Lance Twiggs.
And
His written
as it
statement.
relates to publication, what is your request?
So, Judge, we believe, I believe this has been discussed before on the record, that the state is in agreement that the media should not have the ability to handle or replicate certain exhibits. Because it's video, Mr. Twiggs is shown certain exhibits. So we would agree that this should not be captured by cameras and projected by the media outside of the courtroom. But we would like at least the audio and maybe even the video within the courtroom itself to be captured is the state's position.
All right, I want to make sure, just not the
do you
video
wanna come back
via
when
the
this is
camera. Is
done?
that my understanding?
Correct, that's the state's position.
Okay.
All right. And in regards to this exhibit, is as states exhibit 16, is there any portion of that recorded statement that occurred before the 1102 warning was given to Mr. Twiggs?
Not that we are presenting today.
Okay. All right, turning to the defense.
All
Mr.
right,
Novak.
yes. Let's hear why you want to redact. What's the prejudice? What's the relevance? Or
So I'm going to address first, Your Honor, what Ms. Hunt describes as the procedural issues with our proposed redactions. Many weeks ago, the state lodged their anticipated exhibits with the court. And then the court said, I'm not going to review them. In fact, I'm returning them. I'm sorry. The court said that the court is returning the exhibits to the state. So there is no moment to make objections to an exhibit which the court is not inclined to entertain until the moment, as the court has said many times, until
that I don't believe that that's true.
We have given the state
his shirt has been
the transcript we prepared,
unless someone's got a link or
ahead of time, so that the state could make sure that the transcript is accurate. The state has never said that the transcript is inaccurate. So there's been,
guys, do you mind
all of Monday evening, all of Tuesday,
one thing other
this
than this right
morning.
now?
In fact, the state informed
They
me
gave Charlie's shirt
yesterday morning that they don't agree to the redaction.
Let me see if I can find
So there's no
independent
surprise here.
verification.
And we're actually doing exactly what the court signaled should be done, which is at the time an exhibit is proffered, objections shall be made. This wouldn't be as much of a problem if Ms. Hunt had just said to Your Honor, following Archuleta, and in light of the electronic coverage of this proceeding, and in light of Mr. Robinson's right to a fair trial, the court will consider those portions of the exhibit which are admissible, and the court will not consider those portions which it determines are not admissible.
This is
but it will not be broadcast either audio or video. So that becomes a problem because
What do you have to say?
the categories of objections that we have to this video recording, I'm going to talk about a little bit so that the court understands why Ms. Hunt's suggestion that the entirety of an exhibit, which may not be admissible under the rules of evidence, and that the audio be captured.
Okay, I think we're going to
by
actually
electronic media and broadcast.
Okay, you want to hear this, people? Okay.
Because of our client's right to a fair trial, that's
Shut
a
my
problem.
mouth.
And I don't want to sound flippant, but this is actually the Ryan McBride 1102. The vast majority of this video is Mr. McBride testifying and Mr. Twiggs agreeing. If we were in a courtroom, it would be a leading examination virtually from start to finish. I don't want to say that every single statement by Mr. Twiggs is just an say. So there are two other exhibits that this court will be asked to receive into evidence today, which are text messages and a group chat. I'm just going to distinguish between the two. And so this 1102 statement is basically Mr. McBride saying, and then the chat says this, and then the chat says that, and then the chat says this. He's basically testifying to what the exhibits say. So in some ways, the 1102, those portions of the 1102 violate the best evidence rule, because I have no doubt that those two things that I just talked about are going to be presented to the court by the state.
So the ultimate goal of this is to.
There are also portions of this 1102 which are not relevant and really implicate Mr. Twiggs' privacy rights. And I am not Mr. Twiggs' counsel. As Ms. Hunt said, he has counsel. I don't know if he's, well, I don't want to speculate. But it's not relevant. There are portions of it which are not relevant, and there are portions of it which I think, especially to be broadcast, implicate other privacy
shut
interests.
Up.
So
he's doing it for other people's privacy.
I'm not trying to create complications, and I'm definitely not trying to take the state by surprise, because I went to great lengths to provide the state with a transcript, with a proposed redacted transcript. So if the court wants to look at our proposed redactions, the court can do that without having to compare two documents. The other thing I want to say is that if the court did order ultimately that portions of it would be broadcast in any way, in the courtroom, outside the courtrooms, of the video, because there's no way to communicate to the court efficiently which portions of a video we think are not admissible. It's much easier to do it on paper. So the transcript is just a tool. We have the ability right here in this courthouse to cut the video into the pieces that the court deems admissible. Mr. Ellis tells me it'll probably take a couple hours at the most. So maybe that's also not a concern. There's no delay associated with this in light of the fact that it's Wednesday and this court is going to conclude this hearing.
By the way, we'll come back to this. It's important.
So I've gone beyond the
trying to
procedural
protect the
issues.
people on the
I've
Discord
addressed
chat?
that we think portions of it are not admissible.
Why would
There's
you
no
trying to do that?
surprise. We've followed exactly what the court has signaled, which is I don't want to hear about exhibits until we're in the middle of the hearing, and I don't want to hear objections about it till we're in the middle of the hearing. The litigation over whether Section 1102 is constitutional under Mr. Robinson's federal due process rights and the other rights that were addressed, that litigation does not mean that we should have brought to the court proposed redactions to an exhibit in a hearing which hasn't started yet, in a hearing in which the state hadn't, until 20 minutes ago, even proffered an exhibit. So I understand that the state wants to avoid the substance, and Ms. Hunt is a very excellent advocate for her client. But the reason why the state is going to the procedural issue is because because the exhibit contains significant content that is not admissible even in a preliminary hearing.
Just tell me if you could hear
So
me.
I'm
by
going
the
to
way.
stop
I saw
now.
someone say,
But I do want to go back and say that if the court
Inadmissible
concluded
at a preliminary
that
hearing.
only Your Honor was going to review this exhibit, and the Archuleta rule would be extended to this exhibit, including that it's not going to be broadcast, then
position and not looking at the exhibits, that doesn't preclude any party from filing a motion in limine, which is anticipated
which you
before
didn't do.
anything is moved into evidence. Typically, motions in limine are used by either side on anticipated exhibits or that may come into court, and that allows pre-litigation. So I want to clarify that the court statement, like I'm not looking at the exhibits, is far different than what the parties choose to do and file in regards to a motion in limine. But going to I really want to go to what you've talked about. What specific objections are you making? I want to make sure the request is clear so I can rule specifically on that. What exactly, I think I understand some of them, but I wish for you to articulate what are your objections to State's Exhibit 16.
Never a good thing.
significant.
doesn't
We could do it line by line or page by page. I know we have had
How about
hearings in this
broadly?
matter where the court has wanted to look at transcripts line by line, word by word. We're prepared to do that, but I'm going to give the court
Word by
categories
word. Thank you. That's what you want.
without referring to specific portions there are many portions of it which are not the statement of Mr. Twiggs. They're Mr. McBride testifying on video as to what other exhibits say. And Mr. Twiggs is saying, yeah, that's what it says. Yeah, that's what it says. Yeah, that's what it says.
So he's
That's
a leading
I
question.
apologize. I don't mean to interrupt you. I
Oh, no,
I
it's
just
fine.
want to categorize it and put it in a box. So what is the what objection under the rules of evidence
Well,
is that specifically? What are you
Yes.
boxing that as?
Foundation?
Well, first of all, it's counsel testifying. Second of all, it's hearsay. It's Mr. McBride's out-of-court statements as to what an exhibit says.
Which is admissible at a preliminary
There's a
hearing.
best evidence rule, which I'm sure the court is familiar with, which is that the best evidence of what an exhibit says is the exhibit. So we may have a little bit of a cart before the horse here.
Sure.
Because there are two exhibits that I'm very confident are coming. Under 403, the probative value versus the prejudicial value, especially in light of
So hearsay, relevance,
manner in which this
probative value.
hearing is being broadcast. So we have improper testimony by counsel. We have the best evidence rule, which I think also includes hearsay.
Yeah,
We have relevance issues.
This court chat
and we
is
have
gonna come
403
in.
issues. And so, but what I'm saying is that those are all things that this court can manage, as Ms. Hunt and Mr. Bride have taught us today in terms of the court's preliminary assessments, the court's role as a magistrate, and the Archuleta rules that allow this court to decide certain exhibits will not be viewed or heard by the public because it interferes with Mr. Robinson's right to a fair trial.
Thank you.
And I heard exactly what the court said about the in limine situation, but I do want to just say this, and I hope this is taken in the right spirit. If this court had said to us, I'm returning the exhibits, but if any party has any objections to any exhibits, I want to hear about that before the hearing, we certainly would have done so. And I think that it's probably for a suggestion about how future hearings where there are many or complex exhibits, because there will be such hearings, should be handled, which is we can do in limines before the hearing begins so that the court knows these exhibits, there are no disputes. These exhibits, there are disputes. These are the disputes. And we don't have to waste courtroom time
Like
bringing the court up to
20
speed
minutes?
on what those concerns are. It can all be briefed ahead of time. And we're happy to do that.
Thank you. Well, going to the last point, let me be clear on the record that I don't intend to interfere with the duties of either party. It goes against certain rules, constitutional rights, statutes, case law. I will weigh in, but I never want to put my finger on and say, well, Mr. Novak, here's what I think you should do, or to the state, Mr. McBride, here's what I think you should do. That goes outside my role, and I will not deviate from my role, which is not to interfere with the business of counsel. And I'm fortunate as a district court judge that I have very experienced attorneys who I have watched and have done an excellent job. And your experience, as I stated on I believe in the Pro Hoc Vice, highly experienced attorneys on defense, highly experienced attorneys on prosecution. And so I do not want to get into the business of saying, here's what you should do. I hear what you're saying, but I want to be clear from this point on, in case there's any ambiguity, the court does not need to go into the business of dictating what you feel is in the best interest of your client to the state, what is in the best interest of your client. I staying clear of that, but I appreciate the point you're making, and I hope that clarifies any ambiguity that may exist.
Nobody had any ambiguity.
There was no ambiguity. I don't think that what I was conceptualizing puts the court's finger on anybody's scales. I think it's really about case management. And now I think we're moving pretty far away from the admissibility of this 1102 statement, and we could talk about case management issues. But as I said before, if I say anything else, I'm going to be repeating myself. So I'm just going to stop.
All right. Thank you, Mr.
Thank
Novak.
you, sir.
Appreciate your thoughts.
Put my dog to sleep.
Ms. Hunt.
Good. God, they got a rebuttal. It's relevant.
Yes, thank you, Judge. And as I tried to parse out, obviously we have procedural objections, which may, depending on how the court rules, make the substantive objections moot or unnecessary. But to Mr. Novak's point about this not being by surprise, to our best guess, come up with what the substantive objections may be. I am ready to respond to what I believe they may be, and obviously he's now given categories. But I think we're now at the point where the court needs to exercise its
discretion,
ability and obligation under Rule 104A to decide a preliminary question about whether evidence is admissible. But before we do that, because to argue the substantive objections, I want to actually get into the substance of it. And so I think we need to consider whether this is going to be a closed hearing.
This is all wasted
and
time.
then probably, I don't know, I'm assuming the media attorneys will want to weigh into that, because I do want to quote specific sections to be able to advocate for my position, the state's position on this. I think we will need to get into the meat of what is actually stated here. And so I think the court needs to decide if this is going to be an open or a closed hearing, and hear from the media or any other parties that need to weigh in on that.
This is just
All right. Anything further from the parties as it relates to that?
No, he's getting ready to take a break. I can see it in his face. He's got to pee.
Only that Ms. Hunt invited the media to comment on what the court is going to do. And as Your Honor knows from conducting jury trials and other types of proceedings, sidebars are not for the public. They're the public subsequently.
It's not a video.
It is very standard that sidebar proceedings where
it may or may not be a smoke.
Information is only to be exchanged between counsel for the parties and the court are conducted at sidebar so that witnesses, jurors, members of the public don't hear about those things. And so we are assuming that if the court wants to do this in what we would call sidebar or in a closed hearing, that the transcript of that is going to remain at least temporarily sealed until these proceedings conclude or the court conducts some closer analysis on a topic by topic basis. So potential jurors don't get to hear what the court decides needs to be addressed in a manner which protects the parties' rights.
All right.
Pause. Go to break. Go to break. Who's this? Identify yourself.
Your Honor, if I may, Michael Judd on behalf of the media.
We want to hear it.
A request to close a court proceeding isn't a sidebar, and calling it a sidebar doesn't make it one. The court knows the rules at this point. Any attempt to close a hearing requires that the court engage in some sort of hearing about that closure that is open to the public. It can't be done in whisper. That can't be done with the cameras off. There are occasions where a court may find it necessary to put some portion of some hearing behind closed doors. But the conversation about whether or not that happens.
Oh, come on, right at the worst possible time? Did we just lose it? What's going on? Oh my gosh, it's like the worst possible time. Skip this crap.
And common ground. It appears to be a significant piece of common ground here is that everybody seems to believe that the video interview that is at issue here is very important.
Of course, they wouldn't object like this.
And that, of course, makes people want to invoke protections, invoke closures. From the media's perspective, from the public's perspective, of course, that pushes the other direction. There may be moments of this preliminary hearing. There may be exhibits that do not present significant pillars of support for the decision that the court will ultimately be called on to make as a gatekeeper and as a magistrate. It seems to me.
Yeah, the media lawyers have been
I haven't seen this video. The public hasn't seen this video. It seems to me that this appears likely to be one of those pillars on which the state intends to base its case and on which the court's ultimate decision will likely rest. That counsels in favor of, that will impact the quality of the evidence and the obligation everybody has to keep that evidence reliable and safe. Putting something on the screen doesn't present any of those sorts of risks. Because this is so important. So this interview appears to be such a critical piece of the case being presented here in this courtroom today. The media's position is that it should be shown on the screen and that the public should be allowed to see it as well. To the extent there's any sort of compromise at all, the one that is presented by the state, which would allow the public to monitor and oversee and understand and comprehend and assist with the work being done by the court, then something like the state has provided, which is we would put it, we allow the audio to play. If there is some sort of, it sounds to me like what the state is saying is there's some sort of witness privacy issue that would be served by turning that video off. Maximalist advocates on behalf of the media would always want that video to be on, but I recognize that that may be a reasonable compromise. But the idea of shutting the courtroom down to argue about closure or keeping this recording from the people in the courtroom who are allowed here, the victim representatives, the media representatives, the public itself, is simply a non-starter, I believe, under the rules that govern this proceeding. We ask the court to keep this as open as possible. And if there is any sort of narrowing of the public's right of access here, that it be done only in the narrowest way possible. And
I've seen plenty of power banks over my 15 years of reviewing tech, but this Ridge one quickly became a favorite. So this, a 10,000 milliamp hour battery that's already this small, pretty loaded.
It used to be a fair trial interest. We take that important. We take that, we recognize that its importance. We take it seriously. The court has also over and over again recognized what the right approach to that is to say there are mechanisms in place under Algier to say we do an expanded voir dire, we do a jury questionnaire. We can handle those counter interests. And on behalf of the media and the public, I'd ask that the court handle this dispute that way.
Thank you.
All right, I want to skip over
comment
to the Rumble feed
by any of the parties.
The audio is lower, and they're further ahead on Rumble.
All right, Mr. Novak.
I think there you go. I see Novak coming back up.
Only
two
that I want to make an additional assertion about why the court should handle this. It's a self-defeating exercise. So when the court resolves whether it will hear from us at sidebar, we're prepared to do that.
All right. The issue is sidebar is public because the transcript's open. So it's just because the parties request sidebar and the court invokes the white noise, that doesn't make it private. It simply obscures the noise in the courtroom because that goes in the transcript unless it's a closed hearing. So
then we would like to have a very brief closed hearing to lodge another objection about the publication of this.
Judge isn't buying it.
Of any portion of this exhibit of certain portions of this exhibit beyond Your Honor's eyes. That's what I'm saying.
Thank you.
He's going to have to pause.
All right. Right now, what we're going to go ahead and do, and what I want to do is I want to look at the redactions that you're proposing and take a look at that. And it's also a perfect time to take a break because we need to bring in the monitor potentially for future exhibits. So that's going to give us our 15 minutes. I want to review that so I can be brought up to speed because the transcript, from what I understand, is just a transcript with suggestions of what defense wants to redact. Is that correct?
That's correct, Your Honor. And so what I would suggest, if this works for the court, is we will, something we've already given the state, which is the proposed redacted version of the transcript. I understand that the state wants a video to include there should be redactions. It's not redacted through blackout, it's highlighted. So the highlights are the proposed defense redactions, and Mr. Ellis can make sure that your court staff receive
the exhibit. So being able to quote directly from it, knowing that if it's not a closed hearing, those portions of what I'm saying are going to be on the record and broadcast.
So the court is not making a ruling right now. We're just going to take a break and then we're going to come back on the record. But on the break, I'm trying to maximize the time. And that's why I'm asking, is there any objection to me reviewing what it sounds like defense has sent you, which is just the transcript highlighting what they're anticipating redacting? I just want to bring myself up to speed. So on the next step, when I make my ruling, the court is ready to go.
Okay,
and maximizing the time because we also want to put up a monitor. So there's like 3 things we can accomplish in the space of 15
Fair
minutes.
enough. The state has no objection to that.
All right, Mr. Novak, if you wouldn't mind sending what you sent to the state to the court for review, and we will take a 15-minute break. It is now, let's go a little bit longer. Just I want to make sure everything is in place. Let's come back at 3 o'clock.
19 minutes.
And we'll proceed from there.
They're going to be back. They're going to be back at. All right. 3 o'clock is going to be their time. They're going to be back at 3:10 their time. I'm going to take not this opportunity to walk my dogs. You want to see something funny? We'll come back to this in a second. We can now catch up with What do you have to say, Manny? He's getting bored. I'll tell you what. All right, let's get to some of the. Hold on, this is bothering me now. It's not symmetrical. That's better. Let's get to some of the chat because there's a bunch of Viva. No, we're going to start off first on Rumble. If you're watching this now on Rumble, the dog is on the table. The dog is on the table, people. What's he doing? What's he doing? Go now. He's half on the table. Go to Rumble if you're watching on the Rumble landing page. Click on the video if you're watching it on the Rumble landing page. Click on the thumbs up. Table. Go to Rumble if you're watching it on the Rumble landing page and support our sponsor, enhanced.com. The link is in the description. And support Rumble. Download Rumble Wallet. It's for your own benefit as well. You can invest in crypto at your own risks and loaded yesterday. You can go scan the QR code, tip with crypto. You can tip with gold-backed crypto or invest in crypto if you think gold is going to go up. You can invest in crypto that is tethered to gold, like dollar for dollar, and you can actually redeem your digital crypto for actual physical gold if you want to go to the vaults in Switzerland. And if you want to do that, you can go back. You go to XAUT, which is from Tether, which is now a stakeholder in Rumble, and you can support the channel that way. What we're going to do now is go to vivabarneslaw.locals.com and see what's going on in the chat there. Get some tipped questions over there. And I hope the dog didn't just pee over there. And we'll see what we have going on here. They're on break, coming back at 3 o'clock. It's going to be later than that. We've got 2 tipped questions. Oh, there's a few more. Thoughts on, so I answered this one before we went live, but I'll answer it again now for the benefit of everybody. Thoughts on the following. Do you believe Tyler Robinson acted alone? No, I do not. And I believe that if there is any stifling of investigations, it's to protect who may have been involved in radicalizing Tyler Robinson online. We know that people seem to have had advanced knowledge of this attack, which means that people knew something in advance, and we don't yet know who those people are. And there could be very logical, predictable reasons for which one might want to stifle an investigation into the agitators or actors online. Robinson. So no, I do not believe he acted alone. Do you believe that there was any foreign connection to the assassination? I believe it could reveal foreign. And I believe that there were other actors who were involved online or in the plotting of this assassination. So whether or not they were foreign, I don't know. Whether or not, imagine you found out they were domestic. Well, that would be even worse than if they were foreign. So I don't know, but it's possible. Do you find it odd that they dug up the soil literally right after the assassination? The assassination. What do they call it here? I'm looking at it. It was like crisis management. What was their statement says we paved it to destroy it. No, they didn't say that. People were accusing them of having paved it to destroy the evidence. They're saying we wanted to just get rid of this trauma scene ASAP. By the way, in as much as I believe it's very possible that members of UVU were involved in not securing the roof, you might have them there wanting to destroy the crime scene because it might implicate their deliberate omission of covering a roof and then lying to Team Charlie Kirk, if you believe it, that they couldn't have their own drones to surveil the area because the university was covering the roof. So, A, the official explanation is not patently unreasonable. B, there could be evidence, there could be reason why the university might want to destroy the crime scene or cover up their own neglect. And so that's possible too. What was the other one? How do you explain the shards of plastic and glass in the photo? I'm not sure. People do not believe video evidence. People don't believe photographic evidence, and yet somehow they do decide to believe unclear evidence as to what it shows. I don't know what that photograph shows. From what I understand, if it's to support the idea of the exploding microphone, my understanding is the microphone was not exploded or broken or otherwise destroyed into pieces. So I might have to take that. I'll take that. Oh, now the doctor. Okay, so thoughts on the following. Then we got Mr. Mike. Mr. Mike, here you go for Rumble Premium. Okay, we're actually going to go back to that one afterwards. They're on break. I'm gonna go back to it. Don't worry, you won't hear that for too long.
To the preliminary hearing.
How is this audio?
Defense counsel had been aware since at least April 28th, 2026, when the recorded 1102 of Mr. Twiggs was provided to them, that is how we intended to proceed. And like I said, they had already briefed the 1102 issue, disrupting the hearing.
audio
not,
is fine from here.
I did mention that defense prepared a transcript
It's loud?
of this
Oh, okay, good.
recorded
Fine. Okay,
interview.
good. So we're going to go back to
how the state intended to present it and how we're
going to go to Rumble for the rest of this. And that will be what we go back to. When I hear it in the backdrop, I'll bring it up. Okay, that's good. Hold on one second. What's the question here? Given you what for Viva? Balanced seems good. Okay, good. Now the dog has lost interest in hold on, I gotta show you what's going on here. Here. See, he goes for the tail, and then he's going for the hump. Okay. And I'll show you. Here we go. Look at this. Oh, hold on. He goes for the tail. Yeah. And then he's going for the hump. Yeah, look at this. Right there. Goes to bite his back leg. Goes for the tail. All right. And then he's going for... Nobody cares about that. Now they're playing. Okay, good. Back to vivabarneslaw.locals.com and the tip questions there. Okay, thank you very much, Mr. Mike. Mr. Mike. Alice Elizabeth says, Graham Plattner shot a friend of mine in the head 20 years ago. I'm only coming forward now because APAC asked me to. I have no evidence, but I do remember some convincing details. I think that's intended to be a joke. Then we got Kimmy Hunt, my fluffy Frenchie grand dog Watson, whom I'm dog sitting for my daughter. I love Taco Bell dog. And oh, that's a cute dog. Okay, that dog is objectively beautiful. And that is our tip questions over on vivabarneslaw.locals.com. Let's go to Rumble, because I know that there were a bunch of Rumble rants there that I have not gotten to yet. I want to thank you for the raids. Who are the raids from? Indoctrination, thank you. Because that Discord chat is damning for the case. By the way, when he says McBride was testifying for Twigs, but bullshit. First of all, that's his characterization of it. What he wants to basically say is the objection is leading questions, leading the witness. Testifying, a load of crap. Indoctrination, thank you very much for rating the stream. Jake Monroe Show, thank you for rating the stream. Does the defense just want no audio and no video to try to get Candace Carroll crowd to witness as little concrete evidence as possible? Dude, the moving goalposts that we're seeing in real time now are wild. But by the way, had they started with the conspiracy theory that Tyler Robinson wasn't the shooter, that it was another shooter, okay, not patently unreasonable. But they're quickly evolving into the otherwise not just plausible, but I say entirely defensible conspiracy theory that Tyler Robinson did not act alone. And then the only question is, who else was involved? Were there any agents, CHS, assets involved in any of the Discord chats, online radicalization? But that's where it's evolving to. And that would have otherwise been, that's them now saying, well, all we were doing was asking questions, and we've gotten to what was otherwise a reasonable, defensible conspiracy theory. The idea that it may not be Tyler Robinson, okay, that the images, the videos don't match. People say, well, when he's in the black shirt, he really looks different than when he's in the red shirt. His frame is... Okay, you'll raise those reasonable doubts at trial. Right now, by all accounts, the mother identified her own son from the video. So it could have been that not looking like her own. With Peri Peri Biltong, mild heat, big flavor, 50% protein to keep you going. Try the full Peri Peri range at biltongusa.com. Code VIVA. Fake bullets. I looked it up yesterday because I was like, bullet hit one another. Here, where is it? Bullets hit by bullet. Here we go. This. Everybody's seen the, I don't know that it's fake. I'm not showing it because I didn't bring it up yet. This is it right here. 2 bullets collide. Read it. Yeah. Okay. So I don't know if this has been disproven because, when it came to statistical, what are the odds? There were people who suggested that not that this didn't happen, but that this was actually not 2 bullets colliding at midair as they went through both like in separate directions, but that this bullet, I'm not highlighting the right thing. Where's my Google thing here? Where is my search bar thing? Here, get this out of here. That this bullet here, the darker one, might have hit this bullet when it was in a magazine in a rifle, which would make a lot more sense and be a lot less astronomical. So that's the explanation on that. But thank you, Ginger Ninja, for that. Now, let's get to some of the fighting that we've been having on the interwebs, because addressing, trying to understand. I'm not trying to be right. I want to make sure I get it right. Ian Carroll, who I don't, I'm not convinced he's as bad faith actor as many people accuse him of being. But Ian Carroll earlier today said this in response to, I hate when people answer with yeah, bud, but Paramount Tactical says number one is a total lie. Cole, are we looking at the same thing? We are. In respect of Baron Cole saying, please list the Fed sloppers who have reported the following before the preliminary hearing started. 1, 89 to 95% of the DNA on the screwdriver and towel came from Lance Twiggs. I asked, if that were the case, then I would say, holy shit, Houston, we have a problem. So when I hear something that makes zero sense, I say, maybe I'm misunderstanding something. Paramount Tactical said, number one is a total lie. Ian Carroll says, you see, bud, when you make posts this adversarial and objectively uncurious, it kind of gives away that you're here to fulfill an agenda, not because you care or are curious about the truth. Let's set aside confession through projection as a paradigm through which to view things. Kind of blowing your cover, Gary. Try to blend in a little more. Okay. I seriously and sincerely asked, I'm curious to know if you'll answer, where was it mentioned, reported 89 to 95% of the DNA on the screwdriver and towel came from Lance Twiggs? Just the source. Other than that, trading insults, you don't actually address that part of the tweet. And so then you have from Trisha Hope, the DNA witness yesterday testified to this. The defense absolutely destroyed the DNA evidence. Take the time to watch for yourself. And I respond, I say, I'm watching. Everybody's saying very specific things without any source. What specifically was said? Do you have a link? It's not a snippet, I think she meant. You have to watch the entire thing. The defense picks each piece apart. If you aren't willing to do that, then maybe don't comment. To which I posted the actual video. That is the exact...
I want to make sure I understood this.
Opposite.
You stated, I believe, that the minor contributor was less than 20%, and that it was actually 5%. The ratio is 5% to 95%.
For one of the samples, yes.
Do you remember that?
Yes.
Does that mean the 5% was from Twiggs, and the 95%, that 95% is assumed from the defendant, the Robinson?
When I calculated the statistic, Twiggs' DNA profile aligned with the 5% contributor, and Mr. Robinson's DNA profile aligned better with the 95% contributor.
So they'll attack the DNA all they want. DNA, people can have their issues with how it was done. Is it scientific to begin with? Was it done properly? Chain of custody. They'll do all of that stuff. When you're at whether or not it was a misunderstanding yesterday, because at some point I think that the expert did misspeak, which is why they had to go and correct it. It's the exact opposite. And the reality, which makes a whole hell of a lot more sense based on the theory of the case, is that 89, 95 respectively was Lance, I'm going to screw up myself, was Tyler Robinson. And when you just want to have an understanding and try to have a discussion on X, I feel like I have to play the Jeff Lewis meal deal. Trying to have a discussion on X is like trying to understand or watch the Jeff Lewis meal deal. My dogs need to go outside. That's why they're getting a little antsy. You try to just have a reasonable discussion, and holy crap, does it turn into eat shit and die in about 2 exchanges. But so the bottom line is they'll attack the DNA testing at the trial and try to raise a reasonable doubt that, well, if Twiggs is on there at 5% and 11%, there's a 5 and 11% chance he was on the roof, in theory. Then you're going to have to say, well, in conjunction with all of the other evidence, the videos of Tyler on the campus, and he wasn't a student on the campus or at that campus, in conjunction with everything. If it were just, see what this dog is doing? He's climbing on a table now and sniffing a scented... Don't do that. Oh, he just gave me the look. The dog just gave me the look like, don't you tell me what to do. That's my wife. 1 second. Hello? I'm currently live. Is everything okay? I'll call you back. Bye. Go watch, like, and subscribe. Bye. Not at the trial yet. And so the bottom line, however, in all of that is let's just get clear on the facts of what is being presented during this preliminary hearing. The expert, if she did accidentally say the other way around and misspoke, she clarified, corrected, and anybody continuing to repeat the disinformation to fuel the conspiracies and to mislead people online, understand it, identify it, and act accordingly. I don't want to be one of those people. Here we go. This has to be a joke, by the way. So maybe I'm not going to pick on Patrick Marino, but this level of stupidity is real in some. So Patrick, I'm presuming that this is a joke from you, but when your retort is only, how's that check go? Congrats on being dumb. Patrick, I'm not saying you are, unless you're being serious. Tell me in another post if you're being serious. And if you are, then this insult applies to you. If that's the best you got as a substantive response, congrats. You're the one who is probably getting paid to disrupt. Congrats. And that's that. Now let me just see if he's... Epstein is probably alive. I'm still... I don't believe that one. That is more fantastical than believing he was actually killed in his cell or allowed to suicide himself. But there's certain things, certain theories. People can have them. I'm not going to entertain discussions with them. But let me see. What was his name again? Let me look for the $ thing. By the way, we're at 5:02. They haven't come back yet. Patrick. Let's see if Patrick was being serious or not. Why is he alive? I do judge people who alive. I do judge people who seriously say Charlie Kirk wasn't murdered. I mean, that is, it's a level of insanity that cannot be reasoned with. That would involve everybody, everywhere. The people there didn't. So you didn't know, to the government, to the police, to everybody. So look, you can't have discussions with people who believe crazy things because you'll never be able to convince them otherwise. But I don't blame people for thinking that Epstein is alive. The autopsy, I appreciate some of the anomalies in his ear and whatever. I just think it's too hard to actually get away with that for an extended period of time. Many. Please stop that. Oh, crap. Now we have to buy a new thing we're staying in an Airbnb and he's been chewing up it's a dog-friendly one, but he's been chewing up a plastic thing. Moon landing deniers, I can understand, and I can almost. They have some decent arguments. Again, though, I think that's also too complicated to maintain for any. Hold on a second, I got to make sure this dog doesn't kill the. Oh, you can still hear me. I'm going to keep talking because I don't have my directional microphone. Can you stop doing that? Where is the plastic thing? Hold up. Wait a minute. Stop me correct. All right, I'll take this. I'm going to take this. Here is it. This is what we're going to do. We're going to give the dog something very big. Something very big to play with. Water. 4 liters. And watch this. Listen to the instant. Okay, he's looking at it. He's inspecting. I'll make sure he doesn't hurt himself on any of the plastic. Okay, that might be more annoying than anything else. Might have to take that away from him soon. Candace said it's not Tyler. Well, Candace has said a lot of things. Now, not Tyler. Okay, there's less crazy levels of conspiracy theories than others, but she said a lot of things. Ginger Ninja in the house. With also in vivabarneslaw.locals.com. Epstein said in 2016 that he had his prostate removed due to career. Yes, I read that. It's unclear if it was a joke, how exactly he meant it. And in his autopsy after death, it said he had an enlarged prostate. I didn't know you could regrow your prostate. No, Ginger, I'll pull up that email where he said that. It's not exactly clear what he meant by that. What I want to do now is go over to vivabarneslaw.locals.com, and we've got another tip question that came in. I'm watching the dog run around the house. Viva, don't forget Rumble Rants. Ginger, don't worry, I got them. Bullets in flight are spinning somewhere in the range of 30,000 to 100,000 revolutions per minute. That wasn't 2 bullets colliding in flight. probably static for one, Recortes. Yeah. Anyways, that was the standard explanation. And now he's playing tug of war with me. Okay, you go run around. It's 5:06. They're not back yet. Let's see what else is going on. So those are the fights that I've been having online. And it's what's a bit. And so by the way, the noise. It's not me farting. It's my chair. Oh yeah, there you go. So Brett Weinstein, we're gonna have a discussion far enough down the rabbit hole when it comes to the nature and the types of conspiracies that can exist. To which I say, I think I'm. Is the noise really driving everybody crazy? If the noise is driving everybody crazy, let me know. The dog has now brought he's brought the bottle over to my blind dog, who doesn't see it, and now he's barking in his face, thinking he's tempted him with it. So by the way, I love Brett as well. In the pool, in terms of the types of conspiracies they have out there, I fully am. I would rather stay in the shallow end of the pool instead of going off the deep end, metaphorically speaking. This is too funny. Look at this. You want to see what an annoying dog does? Look at this. Like right in his face. Just right in his face. So MK Ultra. We know all of these things. Whether or not it's conceivable. Another shooter from another angle, George Zinn, who happens to be there to distract. And what if the real shooter got away and the patsy got caught and they have all their... You could write that book. But is that a pink phone? It's orange, which is the coolest color for anything. So yeah, I'm going to wait before jumping off the deep end in terms of but the types of conspiracies that you could conceive of for Winston. Who? Excuse me, sir. This is the type of comment that can get you blocked. I'm joking. Not even that. But love dogs, but you need a bigger one that can hang off of an intruder's arm and bite, and by the time to grab a gun, shotgun by the bed. Oh, I wouldn't mess around with Manny. Manny is he's got a jaw that can actually, so that you can continue to watch the hearing. I'm going to listen to it as I go transport myself to another location. Viva, that looks pink. But they haven't come back yet. It's 5:10. It started off as 15 minutes. It went to 20 minutes, and now we're at 30 minutes, and they haven't come back yet. Let's go to the chat over at Rumble and just see what's going on in the chat, answer some questions, and see if I've gotten everything. I know I got to get the dogs outside before they urinate and or defecate in this place, which I've removed all the carpet. That's adorable. Both my dogs perked up for that. Experimenting with herbs and refreshing summer drinks. Just made one with basil, sparkling water, and lemon juice. And oh my gee, so good. Does anybody know of the original? Okay, let's go up here. By the way, so on the 223, apparently from what the chat said, there's some details that I just got to refresh my memory on. Apparently the 223 round that was found was dropped by another officer, and it was not the 30-06, or nothing to do with the 30-06 that is the alleged bullet. We got the 50 BMG, which from Kentucky Ballistics, she be kicking. Then we got 460, 338 Lapua Magnum, 300 Win Mag, 30-06 Springfield, 762, 762. What do we got here? 65. Okay, and then we got all the other stuff here. So size comparison of rifle, 50 BMGs, because that's like larger than an ordinary finger. Don't do it, please. We don't need extra charges. All right, well, we might have to fix that. Okay. Should have gotten him a dog bone. So that's what's going on there. And oh So those are the relative sizes. Manny sounds like he's having fun. Yeah, at least one person is. All right, let's go to the chat over on Rumble. Don't put it on mute. I'll pee when they come back, and I can let it run, and you can continue watching the hearing. And that's it. But 5:15, man. They may not come back today. I've got it running in the back so I can hear. Let's open up in Rumble and see. The dog's gonna pull. He's gonna pull my headphones out. Don't do it. Don't do it. Don't do it. Get over here. Hey, there you go. Let's open it up on Rumble. See what's going on. Preliminary hearing. Okay, we're in this one here, and everybody will be very much up to speed with the Robinson preliminary hearing. But as far as I'm concerned, there's zero chance this doesn't meet the standards, and you're going to have a trial, and it'll be in a long time, and we'll see what happens then. Judge had to squat, takes time. MLK was shot with a 30-06, separated his head from his spine, blew apart one side of his jaw and neck, and know what the round will do to a human body. That's all I will say. So Landers, I was corrected in that the MLK round exit wound. It went into his face, exited his neck, and then re-entered his body here. Let me. It's funny, actually. You get two differing answers on this, and depending on the day, AI will give you. Martin Luther King did not have an exit wound. The fatal 30-06 caliber bullet entered the right side of his chin neck, shattered his jawbone, several spinal cords, and lodged into his left shoulder blade. He died from hemorrhagic shock caused by blood vessels to the neck. Did MLK Jr. shot leave an exit wound? No, the fatal bullet fired by Martin Luther King did not leave an exit wound. See, this is where I saw confusing answers. Look at this. It's not even. I'm not even showing it to you, so you can't see it. No, the fatal bullet fired by Martin Luther King did not have an. You could not possibly venture a guess. And also, there are anomalous cases of bullets not doing what bullets in the perfect realm of theory should do. And it's Superboss Shaft says the punishment, lying to FISA court and to spy on Trump was, I believe, also 0 jail time. If you're talking about Kevin Kleinsmith, yeah, he got a 1 year probation. No, it was what's the word? A suspended sentence. He got his license back. He was temporarily suspended, got his license back. No jail time. Bullets will bounce off bone easy. Just depends on what the kinetic force is left. Guilty in the court of public opinion. Therefore, it's not a fair trial. Are we talking about died from? Okay. Let me see here. He was clearly cajoled into a plea deal. All right. There is more. Justin, Clinton judge orders Trump to pay E. Jean Carroll $5 million. Let me see if that's. Let's bring that up as we're live here. Fox News. Oh well, we got the non-war, non-never-ending war in Iran is back on, and it's still not a war, and it still has not ended. And it's still not a war, and it still has not ended. Let me see. This is where I go. Here we got solemn. It sounded like they might be coming back. Okay, I don't see anything about E. Jean Carroll. Let's just see here. E. Jean Carroll. Let's see, 5 million. 5 million. Did he get ordered to pay it? 46 minutes ago. Judge orders E. Jean Carroll. Judge orders E. Jean Carroll be paid $5.8 million in Trump's substitute death. Well, this is what pissed me off when Trump was like celebrating the lawfare against Alex Jones. Well, use immunity. How was he not charged with something? And now we know that his DNA is on the towel and the screwdriver. How the hell would his DNA be on the screwdriver? Are they doing that much screwing? Pun intended. I mean, they're doing the screwing, but it's not with the driver. Or maybe it is. Who the hell knows? But the DNA on the towel, I can make jokes. That I can understand. The DNA on the screwdriver, I would like to see the handy housework that Lance Twiggs was doing, touch DNA. No, I appreciate that. I'm just like, the screwdriver. So that means that, Lance Twiggs was using a screwdriver at some point in time sufficiently recently that his DNA was still on it. Touched it in the drug drawer. Which one? Which one had the DNA at 5% versus 11% estimated? By the way, now we're at 520. Just oh no. Okay. So touch DNA. There's so many dirty jokes that you can make here, but look, on a towel, I would expect, this is why you'd expect to find DNA on a lot of cloth and linens in hotel rooms. But on the screwdriver, I've got some questions. Okay. Anyhow, and also the use immunity that he was given is immunity specific to the statement that the statement he gives can't be used against him. But if they find evidence against him or other evidence is adduced through other means that they could prosecute him for, he does not have immunity against that. They just wanted the statement that would help them arrest Tyler Robinson, which many people are going to find suspicious. And others are going to say, well, it's less suspicious because he didn't get blanket immunity for it, which you'd think he would want if it was going to be, a total patsy and have a friend throw, or if the other guy was involved or did it, whatever. Maybe Lammy-tube, as we call it. Why didn't Twiggy have to appear in person? Because this is a preliminary hearing on probable cause where hearsay evidence is admissible, and hearsay by definition is a statement made out of court or a statement of someone as relates to a statement of someone who's not in court right now. So to the extent hearsay is admissible, it necessarily means cross-examination of the hearsay issuer, subject of the hearsay, doesn't occur. Hearsay will not be admissible, or at least admissible under certain circumstances during the trial on the merits, but hearsay is admissible during these preliminary hearings, and that effectively precludes the need for cross-examination, hence why he doesn't need to be there in person. Also, he's an out-of-state witness, from what I understand, and you couldn't even necessarily even compel him to appear as a witness in any event, although if he does not present himself to... Oh, no, that you can't do that. You can't do that. You can't do that. Don't look at me like that. Now he's eating something that can't be broken. Hold on one second. Here, take this. Holy crab apples. So they couldn't necessarily even compel him as an out-of-state witness, but come trial time, if he's not making it, I'm just going to say, because I thought I had to do it's a painless, non-invasive method used to collect samples from the inside of your cheek. I thought it was like mucus. I would have said buccal, like mucal. So I was wrong. I stand corrected. In fact, yeah, was Viva talking? Was Viva talking to? Yeah, and now there's some fighting, which I'm not going to get involved in. Let's go over to vivabarneslaw.locals.com. As we wait, here we go. Okay, we got another tipped question in, and I think it's from tipped Mr. Mike, and I'm not showing it because I forgot to bring it up. Mr. Mike, again, the DNA percentage is a lost leader. It depends where the sample was collected. One area might say 100%, while another might be a ratio. If any DNA exists of any possible suspect is what matters. Also, we could have avoided this delay if the state compelled Twiggs to appear. Not Twiggs may still technically be a Utah citizen. We don't know. No, first of all, I don't know where the disagreement is on the DNA testing, reliability, etc. The only issue is getting clear on what the expert witness said, what she meant to say, and what the actual DNA evidence shows right now. And it was not 89 and 95% respectively for Twiggs. It was for Tyler. And it was a mistake that she made, that she cleared up. And anybody repeating it now to say, oh my goodness, this is good, this is a disaster for the DNA. They will cross-examine the DNA expert and provide their own analysis of the DNA at the trial on the merits, not at the preliminary hearing. But you're getting an idea as to where they're going to go with this. What do we got here? Oh yeah, we got some other. Okay, there's very little seemingly good news to talk about. Where is this case coming back? 5:25, people. It's now been 45 minutes. Run out of things to say until new information comes up in the case. Manny's too quiet. He's got a stick in his mouth now. But it's a But the wasp stung another dog, stung my brother, stung my niece, and I got one of those bottles of Raid that had a range of 5 meters. I got suited up. The locals saw the video, and I blasted that nest. But then afterwards, I stepped on a pine tree branch that went into my heel, like a very sharp thing, and that still hurt, but I got it out. They cut a deal with Twigs to turn on Tyler. It would certainly facilitate a conviction. I mean, I can understand that part, and this was actually Richard Barris's. This was actually Richard Barris's objection, is his understanding, and he's said this publicly on my channel and on his own, Richard Barris, People's Pundit, that he was super pissed off that they basically allegedly stopped looking into other people, stopped looking into other possibilities, because they didn't want to confuse, muddy the waters and make a conviction of Tyler Robinson more difficult. Not that Tyler Robinson's innocent, but that there might have been others involved. And Richard Barris was irate, livid, that his understanding, they conscientiously decided to not pursue other investigations that might have revealed other people acting, because it might have made it more difficult to convict Tyler Robinson. But that is potentially entirely plausible and certainly substantiated based on everything that we know. Alpha Warrior Show in the house. Don't do it. He's going back to the spot. Alpha Warrior Show is in the house. He says, Viva, your thoughts on Tyler's team not waiving prelim, given the alleged evidence they knew would be brought up? I thought they would waive prelim. I have to make sure I understand what you mean by that question. Tyler's team not waiving prelim. I think it not waiving prelim as in it going. That's it. That's it. He might have to spend. It wasn't plugged into the wall, people. Any teeth marks on this? Oh, you think. Don't knock the glass of water over. Okay. People, I need this case to come back so we can get the dogs outside for a walk. He's got something in his mouth. I knew it. So I think they didn't want to waive this prelim, if you mean go straight to trial and avoid. I think that's what you mean by it. They're loving, the more information that comes out, the more people online who are convinced in some more untenable conspiracy theories are going to twist whatever information comes out, spin whatever information comes out, promote and amplify disinformation, and hopefully taint a jury pool where you get one person who thinks Mossad did it by way of exploding microphone. And not that, other agencies could not have been involved, but like I've been saying, even hypothetically, you think Israel did it. You have to go with a plausible way that they would do it, which might more easily be online actors to radicalize individuals to carry out acts of this type of assassination. The exploding lapel, but they did it with the pagers. Yeah, they did it with the pagers because they couldn't get behind enemy lines in Gaza and the West Bank, and that was the only way they could do it. And it was highly ineffective and caught a lot of innocent bystanders as casual. So that's my answer to that. Viva, I love Manny, says Red Team, but whenever you show him on screen or he barks off screen, my dog freaks out. The other reminds me back in the day. What is he even? How much wood do you have in your mouth? That's a good question. Many times, if someone is going to plea out, prelim is waived, and the later plea. No, well, that's my Mr. Mike. That's my theory as to why they're doing it. Who radicalized Tyler Robinson to do it? Just go to the Viva chat or play. Just go Viva. We will chat or play a video. Well, no, because the other thing is I want to be here when the actual thing starts, so that I don't miss sharing the screen. He's down. It was after, how long have we been going? It was after 3 hours. 2.5 hours. It was about the 2.5 hour mark that the dogs lost their cool. You know what I'll do? What do I want to do this while I go do this? He's looking at me. Israel is the sixth secret 51st state. I don't know, it's amazing. You'd think like Israel would be the one to do it and not, to the extent I've said before, and I consider this to be a preemptive presidential assassination, you think like deep state wouldn't want Charlie Kirk out of the picture? And so like you go to a foreign government because it's kitschy. It's like it's the thing of the day. Israel's behind everything. Or could if you want to go with a deep state anti-Trump explanation, a little bit less outlandish, or at least a little bit more historical precedent. Yes, Israel has a long history of assassinating political rivals, political leaders, terrorists. A celebrated one. I mean, I don't know why people think it's offensive to say that. Go look online. They got 48. There were government elements in this. It could be, broadly speaking, Russia, China, whatever, to destabilize the U.S. or anti-Trump, Trump derangement syndrome, go after Trump's biggest ally, and undoubtedly future. Dude, I'm telling you, they're not even coming back today. It's almost been an hour now. When it comes back, I'm going to set it up, and then I'm going to go do the business that I have to do. You got to get a body cam set up for the dog walks. Viva, bring us along. And speaking of body cam, do I find it weird that the responding police officer's body cam went dead right at the moment he alleged to have found the gun? It's a problem. I mean, it's a problem. It's not even if it's true, it's a problem, and not a devastating problem. It's just, it's a little bit stupid. And then if the theory is he deliberately turned it off because of what it would show, I mean, okay, but if it's the setup, then why wouldn't he record what was already the setup to make evidence of the setup? But yeah, look, it certainly is. It's not helpful to the case and the prosecution that the camera happened to go off right after 23 minutes, despite having long. But it's not helpful to the case. Nobody's going to say it is. Is it demonstrative of Israel did it? I mean, they deleted what was on the camera because it was compromising to the case. That's the setup. 27 minutes, yeah. What is the court central time? I think the court is 2 hours behind Eastern. So there's that. Do you guys want to watch? Here, you don't for 2 minutes. I'm going to put on. The dog is definitely looking at me. My goodness. Okay, I'm going to put on Kim Iverson. You guys want to watch 10 minutes of Kim Iverson before we go? Okay, no, I got one more tip question in here so we can do this coming from Japper. And we'll see if I can answer it. If I can't answer it, I will not be shy to say I do not know. Can use immunity be used to develop probable cause for another statement? I did it, or I did X, Y, and Z. You can't prosecute me for that statement. That's the use immunity. But if you find out that I did X, Y, and Z because of a video procured from another person's phone, then they can, even for that statement. That's my understanding. I reserve the right to be wrong, but that is my understanding. Now, where is... there was another tipped question that... a humble rant just came in. Let me add this here and see. Here we go. Body cam died after 23 minutes, so his video covered anything that would have been added or removed later. Nothing burger on cam dying happens a lot, actually. Well, absolutely, for Alpha Warrior, that's why I'm not. It's not towing fed slop. I know when I forget to charge my GoPro, and I'm a guy who's pretty neurotic. I mean, it can happen. But the other thing is like, what's the theory? What's the sinister explanation for which his camera went dead? He deleted footage of Lance Twiggs on the roof. Oh, we can't have that. We got to delete it now. I'll just say my camera went dead. It doesn't really do much to dispel. It doesn't do much to harm the case, and you'd have to really come up with something not outlandish, but pretty creative to say how it was necessary to delete the footage to preserve the theory that Tyler did it. If they kill her, okay, no. But he was also killed literally while he was talking about trans violence by someone who was into furry trans stuff. So, I mean, it's amazing. Yeah, he talked about Israel a week before, and that's why he got killed. But he was talking about trans violence the moment he got shot. And that is not, even by your own logic, more temporally correlative transgender gun violence when he was shot by a furry trans dude. And now you want to say, oh, it's because of what he said about Israel. That's the motive. Okay. Following that logic, it's a stronger argument for the trans motivation. What do we got over here? Let me scroll down. Alpha Warrior shows that defense can subpoena body cam data to see if deletes or in-between files exist. Miss our chats, Viva. Alpha Warrior. Let's do it again. Let me screenshot this and just remind me that we're going to do it. It's not easy on the road, but we will do this again sooner than later. How come they cemented up the crime scene right after the shit happened? We covered that. Whether or not you like the explanation, the university did it. I happen to think that the university has some answers to, has some questions to answer in terms of how the roof was not secured. Whether or not any activists employed at the university were in any of the Discord chats and had advanced knowledge of what was going to happen. And if that's true, then you can certainly understand why they would want to, impede any investigation that might, I don't know what, plowing up the repaving would do to cover up for the university. Court is back in session. I heard something. It was coming out of my ear here. Okay, we're in the presence of counsel.
And
appreciate your patience.
Sometimes it takes time to save time. And so that was the intent of this court.
Okay, here we go.
In addressing what is before this.
Is this audio good?
Counsel, this time I've taken time to look at the video and you, also reviewing what Mr. Novak submitted, the redactions requested, and reviewing
the audio
all
good?
Parts of it in great detail. All right, I want to address the objections before me.
I'm going to mute.
And starting with Mr. Novak, Exhibit 16 is overruled. Turning to relevance as it relates to State's Exhibit 16. And I agree in part and disagree in part as it relates to this objection. So there are portions of the transcript, or I say transcript, but what I really mean is State's Exhibit 16. And I appreciate the transcript. I found that to be helpful. It's a lot faster than trying to scroll. And so I appreciate that being provided. It was helpful to the court. And to be fair, I found it to be a true and accurate representation of the actual recording. So did I listen to every word and compare it? No, but from what I reviewed, I did not find any inconsistencies, just to put it on the record so there's no misunderstanding. But there are portions of the transcript, State's Exhibit 16, which relevance is still not clear to me. However, as the magistrate, I am able to distinguish between what is relevant to a probable cause determination and what is not. And what I take into consideration when I make my ultimate decision about probable cause, I will not take into consideration what is not relevant. So that is a constant balancing and evaluation I'm making throughout this hearing. And after this hearing, my intent is to review everything again, to be thorough. This is not a case where I'm going to be shooting from the hip in making that determination, because this is an important determination. So I will take the necessary time as is required and is as necessary to ensure that the constitutional rights of all parties are upheld. So as I'm making determinations, where I land is pages 19 and 20 of the transcript as it relates to State Exhibit. For purposes of admissibility, the defendant's objection is overruled. Even so, there are portions of this transcript, and again, State's Exhibit 16, that may not be admissible at trial and whose relevance I have not yet determined. In the abundance of caution and to protect the jury pool, the potential jury pool, from hearing potentially inadmissible evidence, I'm ordering that the audio cannot be published in the courtroom or on camera from page 19, timestamp 3255, until timestamp 3548. In other words, the state may publish the audio for all portions of the interview other than that one portion. and when I say audio, I mean audio and video. So both. I recognize there's approximately only 1 minute after 35:48. The state can fast forward to that point for it's an approximate 1 minute and 12 seconds, or may take the time to redact the video as they see fit. So where I'm landing today is up until from the beginning, 3255, that portion I am ruling is admissible and may be published. Again, if the state wishes that last minute and 12 seconds to be played, they can either take the time tonight to redact what the court is not going.
That's from 3255 to 3548.
Right.
Okay, thank you.
Is not publishable in the courtroom or on to be broadcast. Finally, I want to recognize both parties wanted the benefit of the record to be more specific in their arguments concerning their objections. So if those arguments pertain to time step 3255 through time step 3548, I'm willing to allow you to do that in a closed hearing. Please be mindful of the time and keep your argument succinct. With that in mind, do the parties have any arguments they feel I have not considered in my ruling that require a closed hearing?
Yes, Your Honor. And so I'm just going to tell the court what I think the general nature of that is without getting into the details, because
Sure.
I do think a closed hearing is appropriate. Setting aside the 1102 issue and objections, there are statements in this video by Mr. Twiggs attributed to Mr. Robinson. Okay, Mr. Robinson said. There are two other exhibits, which I've said before, I'm confident the state will offer, which Mr. Twiggs says in this video, those are statements by Mr. Robinson. Okay, I will acknowledge that separate and apart from 1102, whether statements of Mr. Robinson of the nature that I'm referring to can be published, not considered by the court, but published without violating Mr. Robinson, would violate Mr. Robinson's due process, would violate Mr. Robinson's due process rights under the 14th Amendment. We previously cited, and the reason why I'm saying this again is not to reiterate something just because if you say it twice, it means something different, but because my colleagues have suggested that maybe my argument earlier was not clear enough. And so I want to make sure it is clear so that the court makes a decision based on the arguments of counsel. The United States Supreme Court said in Estes, E-S-T-E-S versus Texas, 381 U.S. 532, the following. In Rideau versus Louisiana, and that's R-I-D-E-A-U, this court constructed a rule that the televising of a defendant in the act of confessing to a crime was inherently invalid under the Due Process Clause of the 14th Amendment, even without a showing of prejudice or a demonstration of the nexus between the televised confession and the trial. I am not calling the statements of Mr. Robinson confessions, but that is what the state will call them. And so there are portions of this exhibit and the other exhibits that I've referred to which implicate Mr. Robinson's right not to have what the state calls a confession televised. This court has authorized the televising of this proceeding, forms of technology, but I'm just going to use what the Supreme Court says because it's the Supreme Court. So we are very concerned because the court's decision to allow this video to be televised and the other two exhibits to be shown to the camera in the back of the courtroom is exactly what the Supreme Court says violates the 14th Amendment.
So, and I appreciate that clarity. And perhaps, and again, if you want to go into closed hearing, we can do so, or if you want to refer to the pages. So I want to know exactly what you're referring to, whether it's in that 3255 through 3548, which is being excluded, or is it?
It is not. It is earlier, and it's also the two other anticipated exhibits. So we may as well deal with all of it at the same time. It's probably easier to do it in a closed proceeding because nobody has to be obtuse. I don't have to be obtuse in order to protect my client's rights.
No, I appreciate that. And it actually prompts, in order for me to get to that, I do want to ask the state, are you intending to introduce the text messages as an exhibit in this proceeding, the preliminary hearing?
Yes, Judge, we will be attempting to and moving for the admission of the text thread, the Discord thread, and I think, and the note that is referenced in Mr. Twiggs 1102.
All right, and let me take one step at a time, just for clarity. And again, Mr. Novak, I really do appreciate you being so precise. It's helping me parse it out so we can address it, because it's important, and I recognize that you're advocating for your client. And so I want to, the text messages, from my understanding, and either side weigh in, my understanding that those were released to the public months ago in their entirety.
Judge, if I may, they were not released in their entirety. Portions of them were placed into the charging document, the information that supported, in part, the charges that the state has filed. We did not put them that were included in the charging document or included in the charging document.
For some reason, I thought it was as part of an exhibit for a motion. But Mr. Novak, I'm not sure if that's ringing any bells.
I am aware of the issue that the court is commenting on. I think the state needs to account for its decision to publish text messages.
Enjoy the rest of the stream. I'll see you tomorrow.
Directly implicate the Supreme Court law that we're talking about. And I don't want to pretend that I can anticipate what the court's concerns are, but that doesn't cure republication on television of what the state will call a confession in this proceeding. So in other words, this is not like, oh, the cat's out of the bag or the barn door's open. This is another opportunity to violate Mr. Robinson's constitutional rights. And I'm not at all suggesting that somebody is intending to do that. Certainly not, never intend to do that, but that would be the consequence of further televising what the state refers to as, previously referred to as confessions, and certainly would refer to here in this proceeding as confessions. We are so acknowledging that they are statements of a party. That they are statements of a party. We have not, this is all simplified by the court being extra cautious about Mr. Robinson's constitutional rights, considering these exhibits to the extent the court deems that they're admissible and portions of them are relevant, and not further televising them in this proceeding in a manner which we think is inconsistent with what the Supreme Court said in Estes v. Texas.
All right. I appreciate that, Mr. Novak. Ms. Hunt, would you like to respond? Because I understand what Mr. Novak's saying, and there may be a 403 issue as well as it relates to this. And I'm not going to pretend to read your mind, but because I can't do that. All right, Ms. Hunt.
Just to clarify for the record of the court, the state's position is that we would like the audio played, the audio may be captured by the cameras in the state's position, but we never intended to visually put them on the monitors such that cameras can capture them and pause or get the actual exhibits, substances of the exhibits. I believe that was the media's position, if I remember correctly, is that they want everything audio and visually displayed, but the state's position is just we just want the audio played.
Right, but what's so I'm just focused on 16 right now.
Okay, yes, and that's the state's position with regards to Exhibit 16.
So help me understand what's the difference if the audio is played or the video is played on what the court is identifying is, well, first of all, 16 is admitted. So that threshold has been met, but we're dealing with the publication in regards to what is publicized. Because this is going to Mr. Novak's argument, about publicizing that.
Television or on the internet or on the radio, it's going to be broadcast. And so it doesn't really matter whether it's audio or video. And it's actually not Mr. Robinson's video, it's Mr. Twig's video. And when the court mentioned 403, yes, I think the court did accurately read my mind, which is fine with me, but it's unfair prejudice of a constitutional dimension, and 403 is a rule of evidence.
All right, so Ms. Hunt, as it relates to that publication, help me understand whether it's audio or video. What's the difference there? Help me understand that.
I disagree that it's a distinction without a difference. As we've discussed prior in this hearing, UCJA Rule 4-202.02 sub 2 sub J states that exhibits are presumed to be public court records, and it does give the court discretion to regulate access when necessary to protect the integrity of the exhibit or ensure a fair trial. So I do want to recognize that. But that discretion should be exercised narrowly, as we've talked about before with publication regarding this case. What the state is proposing, we believe, is a narrowly tailored accommodation. We don't want to display the full exhibits. Obviously, within zone, and it can be seen, exhibits that the state will then in the future move to admit 16.1, 16.2, the text threads, the Discord threads. So we're thinking that if it's displayed visually, what the cameras will be able to do is pause that, duplicate them, replicate them, essentially have access to those exhibits. What we're trying to do, and maybe they can do or the tone, the context, hearing Mr. Twiggs actually talk and talk through these exhibits, talk through his experience is a meaningful way of presenting our evidence. And so that's the difference we're seeing.
I see.
Obviously, it's up to the court's discretion on how publication is to be made here. We've made our arguments generally about that issue, and we'll submit it to the court. Our prime issue is that the exhibits be admitted into the record, that the court consider them as part of the preliminary hearing standard and bind over, but we'll submit it to the court on publication. But that's the state's position.
All right, Mr. Novak.
I learned a long time ago that when the opposing party says, Your Honor, we're submitting on it, there's a suggestion that maybe the court is going to make a ruling which doesn't require more evidence, more argument from me. But I am going to say that it is fair for Ms. Hunt to say, Your Honor, we wanted the court to see the witness and hear the witness so that the court could make reliability determinations. Because as Your Honor has said, that's really up to you. That's a different issue from the constitutional consequences of electronically publishing what the state will call a confession. Now I've changed the word from television to electronically publishing because I'm trying to be in the 21st century, and the Supreme Court used that word in 1963.
Sure.
Citation to state standards for what is or is not a public document are not the issue. There's a constitutional issue here. And I think that the court has already heard from me replaying of what the state called a confession. That's exactly what was structural error. There was no prejudice question in Rideau versus Louisiana, and that's why in Estes v. Texas, the Supreme Court said, we have a rule. You can't televise what a prosecutor calls a confession before trial. Thank you.
All right. Thank you. I appreciate both parties advocating and arguing. It's helpful for the court. All right, so in taking into consideration the argument, which again, I appreciate the parties articulating, the further edits that the court is going to require to be redacted, starting on page 8, and I apologize, I don't have a timestamp. Starting on page 8, and sorry, I'm just trying to. Let's start. Starting on page 6. Now, let me go back here. Starting on page 6, after 6 minutes and 56 seconds. Going to 20 minutes and 27 seconds for reasons such as 403, under Rule 403. And again, this is simply for publication. This is not taking out what the court was seeing, but the court is trying to take a narrow approach in recognizing and balancing transparency with constitutional rights, and doing so in such a manner that it is meaningful and doesn't diminish the court's duty as a magistrate under the probable cause determination. All right.
Restate those times again, Your Honor.
6:56 until right the line before 2027. From $32.55 until 35:48.
And I apologize, Judge, just to clarify, these timestamps that you just gave, the 32:55 to 35:48 and 6:56 to 20:27, those are just not being published, but they have been admitted for your honor's consideration.
Right. So kind of going through my 3-step process. Exhibit 16 is an entirety, not the transcript, but because the exhibit is not the transcript. The exhibit is the video. That has been admitted in its entirety for the court's determination as it relates to this case. So what I'm talking about here is this is only what will be published in the courtroom and on and captured by the video. Is the differentiation. So what's being redacted, for the lack of a better word, or cut out is what's going to be published in the courtroom, not what the court's going to consider. The court's considering it in its entirety. The court's not going to redact anything in here. It's going to make its own determinations in regards to relevant everything that Mr. Novak noted. I'm taking that into consideration and making those determinations, which the court will do again, because this is not something you do watch once and then make your decision. This requires analysis, and the court is committed to doing that. But hopefully that gives you an idea of where, as it relates to public.
When trying to make the determination that it is going to make a conclusion of this hearing, Utah case law, including the Archuleta case, that the defense has referred to over and over again, stresses that the same considerations that urge for access to a preliminary hearing itself, allowing the proceedings to be televised, allowing people to be in the courtroom, also advocate for access to documents on which the court bases its ruling. Disclosing documents used, this is from Archuleta on page 238 to 239. Disclosing documents used by courts in reaching a decision in a preliminary hearing will discourage decisions based on improper means and will promote conscientious performance by all officials involved in the criminal justice system. Therefore, providing a presumptive right of access to documents filed in connection with preliminary hearings can play a significant positive role in the functioning of that process. I want to reiterate the belief that providing access to the documents on which the court bases its decision in this proceeding is critical. Second thing that I do want to mention, because the court referred to it before, is the fact that without going into the content of the interview itself, I understand from the arguments being made today that many of these references are to text messages. Again, the public doesn't yet have access to that. But I do believe that the documents filed in this case, including the information that was filed days after this, contain many, if not all, of the text messages that are now at issue that are going to be kept from the public in this proceeding. I know the court in previous occasions has said, if it lurks in there, something else is being kept from them that isn't. And so not only does it run counter to the idea that of transparency generally, but it seems to suggest that there is something embedded in there that the public doesn't already have access to when the court denies access to materials in a proceeding like this, that whether or not any of the materials that are now under consideration to be withheld from the public are actually already in the public's domain because they are part of the information and probable cause statements that were filed at the outset of this case. That's all I had, Your Honor.
Thank you. And all right, counsel, if you would like to state your name.
Your Honor, Jeffrey Nyman on behalf of the Kirk family. I've been very hesitant to speak up at these proceedings. We understand it's the state, the defense, and the judge. You're all doing your job. But I feel as if we need to. I want to be clear as to what the Kirk family's position is on all of this. The Kirk family believes strongly that if the evidence is being admitted in this preliminary hearing, it should be made public for the world to see. No redactions. This court has tools at its tools at its disposal to make sure the defendant receives a fair trial. You'll use them if you find that you need to. That's it, Your Honor. To not be transparent here, to not be open, to not let the world see what happened, will create doubt and distrust in the judicial system. And that's not what anybody wants. That's not what any of us believe should happen here. and we'd ask the court to consider the position of the family in making its ultimate decision.
Thank you. Anything further before I issue my final ruling to clarify what's been stated, just so it's clear to all parties?
Yes, we just want to say that we totally respect Ms. Kirk's position in this situation, as well stated by her counsel. Media counsel's suggestion that because the Supreme Court has said the public has to wait for the jury trial in order to hear evidence, because the number one preeminent question is how do we protect Mr. Robinson's right to a fair trial? And with all due respect to the Kirk family, and with all due respect to the media, and with all due respect to the public, the number one concern in this proceeding is Mr. Robinson's right to a fair trial, which means a jury which has not been exposed before it's in this courtroom, under this court's supervision, with this court's guidance, to pretrial information of this nature.
All right, I do have a follow-up question for you, Mr. Novak, returning to the Estes case. It's an important point. I want to make sure I fully understand it before I issue my final ruling. My understanding is Estes cited to a dissenting opinion in Rideau.
Rideau, yes.
Rideau, my French is bad.
Mine too.
That constructed a rule that publicizing a confession runs afoul of the 14th Amendment. But that didn't appear to be the holding. It was the opinion talked about coerced confessions being put out to the public. Could you cite to Estes that supports
the portion that the court is looking at is exactly what I would read to the court. It says we constructed a rule. Now I understand there's a parentheses there where it refers to a dissenting opinion in Rideau, because I think it is. But what the court says in Estes is that televising, I'm going to paraphrase a little bit, televising what the prosecution calls a confession de facto violates a defendant's 14th Amendment right to due process without a prejudice. Why is Estes citing to a dissenting justice? But what Estes said is we constructed a rule. It's not a reference to a dissenting opinion. And I think when the Supreme Court says we have a rule, we should just take it at face value that that's the rule. I understand what's in parentheses there is a little confusing, but what the Supreme Court is saying in Estes is we have a rule. And if I may have one moment. The Estes opinion was written by Justice Clark. There was a concurrence by Chief Justice Warren, Mr. Justice Douglas, Mr. Justice Goldberg, and then there were dissents by Justices Stewart, Black, Brennan, and White. So we could spend some time deconstructing that, but it's a 5-4 opinion of the United States Supreme Court saying what rule they adopted in Rideau versus Louisiana. It's a 5-4 opinion. And I would have to sit down with the cases, just like Your Honor probably is wishing it had time to do right now. The court had time to do right now, but it's a 5-4 opinion of the United States Supreme Court saying what the holding in Rideau is.
Thank you. All right, I appreciate that guidance, Mr. Novak. So, taking into consideration all the factors, the previous edits, starting at from 3255 until 3548. Does that comport with what I previously said?
Yes.
All right. And then from 3548 to the remainder 37 can be included. So there is that gap, but that can be included. And part of the reason in responding to the media, and it's an important point, and to the representative for victim representative Erica Kirk, is I recognize the importance of transparency. I also recognize the importance of balancing constitutional rights, and it is a fine line. One of the reasons why for these edits includes under my analysis under 403, going to the last part, needlessly presenting cumulative evidence. And based off the representation of the state that the text messages may be introduced, the court is ruling that this may be revisited in case that doesn't happen. But to throw back the curtain, much of this is going to be considered by the court. I'm balancing all these competing rules, constitutional rights, as well as transparency. And sometimes it is that is the ruling of the court as it relates to State's Exhibit 16. Turning to the state, do you wish to make the edits as identified by the court and play it tomorrow to publish it? Or final copy, if you could send it to defense to review to us to form, just to make sure it comports with the timestamps that the court has identified. And I know this has been a long conversation, but I just want to make sure everyone understands, okay, this is what the court said, and we're all on the same page, that what is before that's being presented reflects that. So not downing the state, simply allowing everyone to review it before it is introduced into court.
Absolutely, we will do that.
All right. On this issue, anything further?
As to this exhibit, no.
All right. Well, Ms. Hunt, let us move forward. Being that you indicated that you're going to prepare this for tomorrow, how would we like to proceed for the remainder of our time together?
Yeah, just a moment.
Of course. And I know the state's engaged, but if someone could send a copy of that to the court after it's been reviewed by counsel so the court can review it to double check that it comports with what I said, to make sure that it reflects what I was intending to reflect. That way we can save time as well. Thank you.
Do want to point out that there is one additional exhibit which we think the state will offer through Mr. Davis. I'm sorry, Agent Davis. Agent Davis, as to which we proposed redactions. It's 5 screenshots of Mr. Twiggs's phone. It's not a 25-page transcript. I'm not suggesting that we should argue about that now, but I'm just making the court aware of that. It's a much simpler exercise. It's not nearly as complicated. I think that's the only one where we proposed other redactions. But the publication question still remains as to all of the asserted statements by Mr. Robinson. So it's all of that is part of the Estes issue. I just want the court to be aware of that. And I understand it's hard because the court doesn't have all those exhibits in front of it. But I just want the court to understand. I think that all of the argument that we've had with respect to the transcript sort of lays the foundation for the legal issues, but it's going to come up with respect to those exhibits as well. And the comments that the court made about 403, I understand it with respect to relevance and admissibility, but I'm not sure how 403 applies to the televising of statements prosecution will call confessions. So maybe that's something.
It was a different prong that I was addressing.
Good. Okay.
The duplicative part or cumulative part as it relates to the text messages, and that's why I reserved that if it doesn't come in, then it can be revisited to the redactions that's made public.
For evidentiary purposes as opposed to for publication purposes.
Right.
Understood.
Right.
But if the court wants to recess, we have no problem with that.
And so just can help us move forward, because I want to look at in detail what you're citing to. It's difficult on the fly to jump into SDs and go to a portion, and I want to give your argument full consideration. It's a suggestion if you can. I know you're extremely busy, but it may be helpful if you choose to. If you choose not to, I will certainly allow the time for it to argument. I just want to make sure I'm fully up to speed as opposed to trying to shoot from the hip there.
When the court says, I'd like to know which exhibits and what the legal issues are ahead of time, so that at 9 a.m. the court has already had an opportunity to understand what's coming, we're happy to do that. And I'll try to get something to the court by 8 a.m.
I appreciate that. Thank you, Mr. Novak. And if you wouldn't mind, obviously, sending a copy to the state as well.
Oh, of course,
so
of course.
All right.
Is the court referring to a formal filing?
No, just if
a bench memo.
A bench memo, and that all sides can have a take a look at, just to prepare. Again, in light of efficiency and trying to maximize our time and give as much weight and time to addressing these issues fully, as opposed to trying to hit them at the moment and doing a deep dive when it's a little bit more difficult. So
happy to do so.
If you'd like to, I would entertain that to the state. If you want to confer and talk to see where you are and want to do the same, certainly you are entitled to do so as well.
I think we plan on doing that.
For this afternoon.
Not the state.
All right, to defense.
No, thank you very much for your time, Your Honor.
All right. Court will be in recess until 9 o'clock tomorrow morning.
All right.